I went ahead and set this. He's made a motion for Nelson hearing, so I just thought it would be prudent to go ahead and set it for hearing.
All right, Mr. Russell, what is the problem you're saying with Ms. Flowers? Let me put you under oath. Please raise your right hand and be sworn. You swear the testimony you give before this court is true, so help you God.
Yes, I do.
Okay, thank you.
Your Honor, I feel Ms. Flowers and Fish Counsel. I asked for the following: number one, downward departure. I never had one. Number two, mental health court. Number three, drug rehab. Never been to drug rehab. Number four, negotiate offer. She said no to all the above. She will not ask. Number five, she also stated she spoke to my dad recently. She never spoke to my dad, only once in the beginning of my 8 months of incarceration. On number six, on June 24, 2024, Ms. Flowers was very aggressive in statement. She was tired of continuing her clients and has become aggravating and a nuisance. Number seven, she was trying to force me to sign without negotiating with state. Number eight, Ms. Flowers has refused to do anything I asked her to do. Number nine, Ms. Flowers showed me that she has no interest in working on my behalf. Number 10, Ms. Flowers makes negative statements concerning her clients. These are the 10 reasons why I feel Ms. Flowers is insufficient counsel on my behalf. Thank you.
Ms. Flowers?
Yes, Your Honor, just to respond, Mr. Russell was charged. He has two VOPs as well as a new law case.
Can you pull that microphone down a little bit?
I have negotiated with the state on several occasions. I actually was able to get him a really great offer. His new law, he's charged with trafficking in a substance that has a 7-year minimum mandatory sentence. It's a very clear-cut case. I was able to get, I did negotiate with the state for a guideline offer in lieu of a minimum mandatory offer. He did not want to accept that, so I told him that I couldn't make the state make an offer, that I had gotten the best offer I could from the state, and the options were to either accept the offer or set for trial, that I was prepared for trial. And at that time, he voiced his concern for a Nelson hearing. I have negotiated extensively on his behalf. I'm not a magician. I can't make up the facts in this case. I can only negotiate so far. And I do believe that Mr. Russell, our communication is completely broken down. I do meet with him, but he really doesn't listen to anything I have to say. So I don't remember what other allegations he was stating, but I have.
She says she's got a plea offer that comes off a minimum mandatory sentence.
My arrest was an illegal search, sir. She will not fight for that.
Your Honor, he was arrested on a warrant and searched on a misdemeanor warrant and searched incident to arrest.
State versus Dickey says you can only pat down the outer garments for weapons to protect the safety of the officers and others. The officer immediately went in my pocket.
Well,
I've explained to Mr. Russell I cannot file motions that I believe to be frivolous.
she's not ineffective, but apparently there's quite a breakdown here. So I'm going to find there's a conflict, but Ms. Flowers certainly is not ineffective, so I'll appoint another attorney. They may have the same argument. They may have the same situation. Ms. Flowers say that's not a proper motion. If that's the case, you're on your own. You don't get another attorney after this one. You understand that I'm appointing? You're not an attorney. So you can represent yourself if you want to. And you may be looking at some serious time. What's the next person on the list? Charles Williams? I don't know. Who's Charles? That's not right. Jason Cobb. All right, court appoints Jason Cobb. If you don't get along with him for some reason, you're probably looking at being on your own, trying to try your case on your own. Okay?
Thank you.
All right.
Judge.
prepare me an order, Ms. Flowers, if you
Yes,
don't
sir.
mind.
Yes, Judge. Yes, Your Honor. Good morning. Again, Jennifer Flowers with RCC on behalf of Cordell Thomas. We're here today on a motion to dismiss in case number 24CF24. I filed the motion, and if the court would allow me just to go through the brief points.
Okay.
Judge, forgive the state. We're going to ask for a continuance in this case. Ms. Leone is out of the country. She also needs to review a deposition that was taken in this case. So I believe it'd be prudent for the state to have an opportunity to review the transcripts or the recording of the deposition. So we are prepared to argue the motion to dismiss, but we're not ready at this time, Judge.
All right, when's our next, they say they're not ready, that the prosecutor that is handling the case is out of the country. So they need to have an opportunity, the person that's handling the case is not available. So when is the next miscellaneous?
I believe it's the 8th
8th
of August.
August, so that's just a week or so.
Ms.
She'll be
Leone-
back she'll be back the 8th of August?
Ms. Leone indicated to me in an email just the end of last week that she would not be here on the 8th and said not to set anything for her on the 8th. So I had to reschedule something that I had said.
Oh, okay, so what is the next one after that? August 29th?
And Your Honor, I would ask if it would be possible, this is a older case. He is, I believe the case law is pretty clear. I understand that the state needs to review the depositions were actually done originally with ASA Glisson, and then she left, and then the case has gone to several different prosecutors. And I would just ask if the court would allow and if the state would accept this, if we could get those transcripts or recordings to maybe someone that could review them, so that we don't have to
Hang on a
wait.
second, he's here on, this is 24 CF 24, right?
Correct.
And he's being held on 24 CF 906, correct?
Correct.
So he's sitting in jail on 24 CF 906 anyway, correct?
Well, he does have a bond. The bond is revoked in this case.
What's his bond on 906?
I believe it's upwards of about
Yes, right.
50,000.
Yeah, but if there was, I was, like, she had come and told me that there was, like, she was gonna put in the dismissal and actually for, like a 5,000 signature bond, Your Honor.
Well,
But,
our plan.
I didn't know, I didn't know this was, none of this was, I'm trying to get back to my school time and, Your Honor, I thought this was already gonna be just like.
Well,
over with.
I just found out recently, just yesterday, that Miss Leone was out of the country, so I wasn't able
Well,
to
you're
communicate.
in jail anyway on 24 CF 906. There's a bond set, which whether you can make or not, I don't know. What's the bond on 24 CF 24?
He had posted a bond and had he was out on bond and then was rearrested, and so his bond in this case was in 24 CF 24 was revoked. So we're just asking that as soon as possible we could hear the motion to dismiss. I believe that once the state actually takes a look at it and is able to listen to these recordings,
We'll
that they
try to-
will agree.
See, I mean, if I dismissed it for some reason, if I find out it's dismissed, I mean, if I grant his dismissal, I don't know anything about, I hadn't heard any facts yet, but if I grant his dismissal, he's still sitting in jail on 24 CF 906, correct?
Correct, unless he's able to post that bond.
Judge, if we do set it for August 8th, I'll take a look at the evidence and the motion to dismiss, and I'll be prepared to argue it on August 8th. I don't want to
Okay.
have,
We'll bring it back August 8th.
prejudice against the
Thank you, Mr.
defendant.
Strauss.
So we'll bring it back August
August
8th.
8th.
Your motion to dismiss is set for August 8th,
Thank you, Your Honor.
okay? That's just a week.
Okay.
Okay, thank you.
Thank you, Judge.
So what are we doing?
Coming back August 8th.
August 8th.
So is one of the cases already dismissed? Is there no action on one of them?
No, I mean, we're coming back to hear your motion to dismiss on August 8th.
The prosecutor that was supposed to, is on the case is out of the country.
So
had an
another
emergency and
another
she's out of the
prosecutor is
country.
going to take over and argue the case on August 8th. Okay? Thank you.
No, we have depositions set.
All right, thank you.
Thank you. And I believe that's all I have on, okay.
That's it?
Yes. Thank you, Your Honor.
All right.
I have a couple out of custody, if I may, Your Honor.
All right, Mr.
First,
Gibbs.
first out of custody, Judge, I have Mr. Bobby Bean.
All right.
Your Honor, Mr. Bean is present approaching. We've reached an agreement, if I may approach.
The State of Florida versus Bobby Moore Bean, 24 CF 29. Mr. Bean, would you please raise your right hand to be sworn? You swear the testimony you give for this course the truth, so help you God.
Yes, sir.
You want to enter a no contest plea to the charge of driving with license revoked, third-degree felony, and leaving scene of an accident without giving required information, a second-degree misdemeanor. So you want to enter a no contest plea to those charges, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs done for you on your case?
Very happy.
Court finds the plea is freely and voluntarily entered. Court accepts it on count 1, 12 months probation. Adjudicated guilty, $100 cost of prosecution, $415 court costs, $150 PD fee. Must be on GPS monitor at no more than $1 per day. On count 2, you're sentenced to time served. Adjudicated guilty.
We'd request to waive cost of supervision on that supervision, Judge.
Waive cost of supervision
Thank you,
granted.
Judge.
Okay? Thank you.
Brandon, and then here you go. Thank you. Judge, the other person that I have out of custody this morning is Mr. Delroy Durham.
Durham?
Durham, yes, Your Honor, 24 CF 1417, 24
Okay.
CF 1419. We filed a motion to recall the KPS. He was supposed to be here Thursday, Judge, for an arraignment. Unfortunately, did not make it. I believe he was informed that he had quote-unquote court the 26th and confused that with August 26th. So we're asking to recall the KPS. He's been in contact with our office. It's not unlike him. It's unlike him, actually,
Has
Judge.
he been
to this court.
arraigned?
He has not been arraigned yet. We would otherwise enter a not guilty plea.
All
The
right, well,
state has
this,
no objection, Judge. to
okay,
recalling the
24
KPS.
CF 1417, Mr. Durham, you're charged with trafficking in meth, possession of a weapon by a convicted felon, attempting to flee police officer, drug possession without a prescription, false ID to a LEO, and driving with suspended license. And it looks like in 24 CF 1419, possession of a controlled substance. So your attorney's pled you not guilty. Asked for a jury trial, so we'll set you for, what's the day, September 6th?
Today, Judge, is July 30th. The next is August 26th, and then we have an October pretrial after that.
Set it for October. What's the pretrial?
I believe
Somehow this
that's
is
going to be October 31st.
These dates are not. October 31st,
Or no, I'm sorry, October 28th.
October 28th, okay.
That's our next.
I'll recall the capias.
Thank you, Judge. There's both cases, 24-14-17 and 24-14-19. Are you showing any others? Okay. Those are, yes.
Yeah.
Thank you.
Don't mess
Thank
up,
you.
because I'll have to, don't, show up, okay?
Right, yes, sir.
Show
I just
up,
got confused
okay.
with the dates.
Yeah, get with Mr. Gibbs.
Yeah.
And so your next court date is October 28th,
Thank you, Judge. Yeah.
okay?
Give me a call. Oh, and Judge, I think we need to vacate the forfeitures and reinstate the bonds. I know his bondsman contacted me. I'm not sure if that's something that
Send
we
me an
do.
order.
We
I'll
can send you an
vacate
order.
the forfeitures and reinstate the bonds.
Thank you, Judge. We'll send an order. Yeah, give me a call.
If y'all get the case worked out, move it up.
Absolutely, Judge.
Oh, okay.
That's-
Mr. Durrell?
Is he already here?
Your Honor, I have already gone over the plea with Mr. Bunkley. This is going to be a written plea. I just need him to sign it real quick. If I may approach, Your Honor?
State of Florida versus Arkita Sean Bunkley, 2015 CF 998. Mr. Bunkley, would you please raise your right hand and be sworn? You swear the testimony you give for this court's truth, so help you God?
Yes, sir.
Okay. You want to enter a no contest plea, the charge of possession of a controlled substance without a prescription?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of your rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Durrell did for you on your case?
Yes, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Sentenced to 18 months, Department of Corrections with credit for time served, standard fines and costs, concurrent with 2016 CF 1188, and adjudicated guilty. Okay? How much time have you got already?
How much time in do I have?
Yeah.
Close to,
On this case, not on this.
I think I bonded out on this case, sir, like the next day. So, maybe like 3 weeks now since I've been back
Okay.
here.
All right. Well, good luck to you. And when you get out, don't break the law.
Yes, sir.
Okay,
Thank
thank
sir.
you.
Yes, sir.
I believe that's all I have today, Your Honor.
Thank you.
Morning, Your Honor. Tim Gibbs on behalf of Dakota Coffee. Judge, this is 23 CF 2767, 23 CF 2768. We've reached an agreement, if I may approach.
All right. This is State of Florida versus Dakota Joseph Coffee, 23 CF 2767, 23 CF 2768. Mr. Coffey, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God. You want to admit that you violated probation in these two cases?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Did you read the plea agreement form yesterday?
Yes, yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea?
Yes, Your Honor.
Anyone force you or threaten you to enter this plea?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Court finds the plea is freely and voluntarily entered. Court accepts it in 23 CF 2767. Probation is reinstated, modified for the remainder to be on community control. $100 cost of prosecution, $150 PD fee. Enter and comply with Responsible Fatherhood Initiative Program with DCF. Counts 2 and 3, the court's going to revoke and terminate. And time served. And in 23 CF 2768, the court's going to revoke and terminate and sentence you to time served. Adjudicated on all cases, all counts.
Thank you, Judge.
Guilty.
I'm
Okay?
sorry, that should be withheld still on the felony where he was reinstated, Judge.
Oh, all I saw, you got withheld and adjudicated, so
Yes, Judge.
it kind of confused the old judge here.
Sorry about that.
So which one is withheld?
The only one that's staying withheld, Judge, is the felony count on 2767 where his probation was reinstated.
All right,
That count.
23 CF 2767, adjudication is withheld. I'll make an arrow to that one.
I appreciate it. Thank you.
And then adjudicated is on to 23 CF 2768, correct?
Yes, Your Honor.
Okay.
Thank you, Judge. Fingerprints, and you'll be good to go. Thank you.
Who we got next? Davis?
Yes, Your Honor, I think we're pulling him now. Your Honor, Tim Gibbs on behalf of Jonathan Corey Davis. Judge, this is 22 CF 2802. We have reached an agreement, if I may approach.
All right. Mr. This is State of Florida versus Jonathan Corey Davis, 22 CF 2802. Mr. Davis, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God?
Sir.
You want to enter a no contest plea, the reduced charge of aggravated battery with deadly weapon causing great bodily harm, a second-degree felony, correct?
Yes, sir.
And also no contest to giving a false name to a law enforcement officer, first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
I did. Yes,
Did
sir.
anyone force you or threaten you to enter this plea?
No, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count one, the reduced charge of aggravated battery with deadly weapon causing great bodily harm, you're sentenced to 51.15 months DOC with credit for time served, $100 cost prosecution, standard court costs, $150 PD fee to collections. Restitution is ordered. Court reserves jurisdiction as to the amount for a period not to exceed 180 days. On count two, the misdemeanor, you're sentenced to time served, adjudicated guilty on both counts. Both counts. And how much time have you got in already on this?
It's got about 21 months, I think, Judge.
21 months, so you got a good portion of it
Yes, sir.
done. So when you get out, just don't break the law, okay?
He does.
I promise you I will not.
He does have a Leon County hold that we were hoping to be able to try to address as well, but of course that's Leon County. I was not able
Yeah,
to
I
find
can't
it.
help you on Leon County, but
Hopefully he can get over there and resolve
maybe,
that before
yeah.
he goes.
all right. Well, good luck to you, and when you get out, I don't know what caused all this, but just don't break the law, okay?
Yes, sir.
Thank you.
Good luck. Your Honor, Tim Gibbs on behalf of Mr. Ronald Franklin. Judge, this is 24 CF 1283, if I may approach.
All right, this is State of Florida versus Ronald Dale Franklin, 24 CF 1283. Mr. Franklin, you want to enter a no contest plea to the charge of possession of a controlled substance, a third-degree felony, correct? Correct?
Do you want to enter the plea today?
Yes, sir.
Did I swear him in?
I don't think you
Would
did
you
yet,
please
Judge
raise
Hannon.
your right hand, Mr. Franklin, be sworn? You swear the testimony you give before this court's truth, so help you God.
Yes.
You want to enter a no contest plea to the charge of possession of a controlled substance, a third-degree felony, correct? Did you read and sign this plea and sentencing agreement form? You did?
Did you just answer out loud?
I'm sorry.
Did you sign that form yesterday?
I did, yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Gibbs has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it, sentences you to time served. $100 cost of prosecution, $5.15 court costs, $150 PD fee due within 180 days. Adjudicated guilty. And order you not to break the law in the future. That fentanyl, I hear, kills people pretty easily, so stay away from that. Thank you. They listen, too, when I order them not to break the law.
That's enforceable, for sure.
I think that concludes my business, Your Honor, if I may be excused.
All right,
Thank you.
Ms. Rivers? This is State of Florida versus Robert James Strauss, 20 CF 3247 and 21 CF 247.
Your Honor, there's a direct conflict that would prevent us from representing Mr. Strauss. He's a complaining witness in a case that I already have. Our office is in the process of filling out paperwork for a conflict. I did tell Ms. Flowers about it this morning when she was here.
All right, if there's the public defender is certifying they got a conflict, so I got to let them off and put the regional conflict council attorneys to represent you. Okay?
We'll send a motion in
That'd
order,
be
Your Honor.
Ms. Flowers, and she'll be up to see you. When is his next court date?
If you want to put it on for the 8th, then that would give her an opportunity to meet with him.
The 8th?
Is that the next court date, or is it the 6th, the August?
It's the 8th, I believe.
Is he going to enter a plea or something, or?
Your Honor, we definitely have an offer that I can convey to Ms. Flowers that probation has
Okay, bring it
presented.
back August 8th. Next week, maybe get it resolved. Okay, thank you. This is 24 CF 1284, State of Florida versus Kevin Paul Lack.
Yes, sir. Judge, I believe this is on for a bond hearing.
All right.
Sorry, Judge, just looking for my notes. Judge, let me just take testimony then from Mr. Lack.
What bond is he under already?
Let me see here. Judge, if you can pull up my motion or give me a second, let me grab my computer and I'll pull it up. Because I've got all that in the motion. Here we go. All right, Judge, he's been incarcerated since June 2nd. His current bond is $4,500, but he cannot make that bond. He's asking for a signature bond. He's self-employed as a handyman. He resides here in Crestview and has lived in this area for 19 years.
Is that 4,000 on one count and 500 on the other?
Sounds about right. The other count is DWLSR, Judge.
Yeah.
That would be my guess,
Has he got a
Judge.
prior record?
Judge, I have his prior record in front of me. I don't want to interrupt.
No, you're fine.
All right, go.
So this is not Mr. Lack's first time in the court for domestic violence battery. He also failed to appear. So the bond statute provides that when determining when to release a defendant on bail or other conditions is the nature and the circumstances of the offense charged. Mr. Lack's wife is on hospice. She's on oxygen, and what's alleged is that he chokeslammed her. So I believe the nature and the circumstances are malicious. The second one is the weight of the evidence against the defendant. Well, we sent over a stipulated order requesting to perpetuate the victim's testimony because she is on hospice and because she's not on oxygen. She spoke with my office earlier, and she is dying, so she's not able to make it here today. She is concerned with her safety, given the conduct of the defendant. Because she's on hospice at her home, at the marital residence, essentially, she doesn't feel safe if he's to be released. Furthermore, he's already sent a letter to her, and he addressed it to his sister or somebody's sister, but it's addressed to the marital residence, and no one's sister lives there. And he wrote, essentially had contact. At very minimum, it's third-party contact because he asked his sister to ask the wife, for forgiveness and to drop the charges. But the state's position is this is contact. It's addressed to
Does he have a failure to appear on this case?
He does not have a failure to appear on this case, Judge, but he has, if I may go through his record, 2020 he got a DUI, and he had a failure to appear in that. I don't believe the state had any action, but nevertheless, he failed to appear at a scheduled court date. 2020, another contempt of court violation against protection against domestic violence, forgive me. So even when the court imposes rules to make sure that he does not harass the witnesses or harass the victims, he wholly fails to listen to the court. And the only thing that's going to stop him from speaking to the victim or harassing the witness is him being behind bars, Judge, and having a cash professional bond. And I believe the first appearance, Judge, got it right on his.
That contact or alleged contact is, I'm just going to leave the bond the way it is.
Yes, sir. Just wanted to correct. It's $1,000 on the DWLS and $3,500 on the other case, Judge.
All right. Thank you.
Thank you, Judge.
Thank you, Judge.
Thank you.
Right. Judge, you've got Destiny Lige on the docket. It's for a competence review. I brought up the court's previous order in the case. Department of Children and Families was ordered to provide a report prior to today, and today's court date was referenced in the order. My secretary reached out to them last week because we still didn't have an order, and we've not had a response that I'm aware of. My secretary was out Friday and is out yesterday and today.
Who is supposed to prepare the report?
Department of Children and Families is whose custody she's under. She's in the Florida State Hospital. And they were...
We'll set this for August 26th.
Judge, I'm going to suggest that we set it not on a docket day because it's going to be kind of crowded. Maybe set it on the 8th.
All right, the 8th, but that's just a week from now.
Well, if you want to set on the 26th, that's fine, Judge.
Well, what about August 29th?
That would, I think, probably be better. It does give them a little more time, but...
August 29th, that's a miscellaneous day, I think.
And we can move it up if we get the report.
Yeah.
Yes, sir.
All right. Next one, Michael Joseph Manning. All right. Bond hearing.
Yes, sir, Judge. Sorry, Judge, I printed stuff out and it did not make it in the file.
Isn't Mr. Manning just in court like last week or something, out of custody?
No, Judge, he's been in custody for quite a while.
Okay.
He was out of custody long enough to violate his pretrial conditions, though.
My understanding is that one of the cases either has been or is about to be null-prossed, and is what we have remaining the possession of controlled substances.
That is correct.
All right, and you're seeking 1129 on that?
I believe I'm seeking 12-1, but I would allow 1129.
You can't give him 12-1 on a misdemeanor.
I have him on a possession of controlled substance right now, so that's not a misdemeanor.
Okay, all right, so you did not
I-
null-pross the whole case, you just have
So there was two
null-pross the
cases?
felony on the other case?
Yeah,
Okay.
I null-prossed the felony and the narcotic equipment. I null-prossed that whole case, but he has a new case. When he was out on bond, he picked up new charges. And so the pattern of behavior of the defendant is stealing and doing drugs and being caught with drugs. So we got to give our merchants and our business owners a break from Mr. Manning.
Are we on 24 CF 1268?
Yes, sir.
And so I have possession of a controlled substance without a prescription, a third-degree felony, and possession of narcotics equipment. I think that's a first-degree misdemeanor.
It is, Judge.
And you're null-prossing which one?
It's a different case.
It's
that I
on a different
null-prossed.
case. The judge found no PC for the felony on a different case, and so he's null-prossed that. I did not file a motion on that case because he already had an ROR bond on the
Why don't y'all,
remaining
why don't we
count.
bring back Mr. Manning on August 8th, and maybe you can work out a plea?
Give me just 1 second.
The state does not plan on departing from its offer, just based on the conduct of the defendant, Judge.
It means it's dismissed.
Okay.
All right, Judge, let's just go ahead and have the bond hearing at this point, because unless the state's going to budge on the 12-1, I don't think Mr. Manning's going to budge on his request for probation. The only other thing I could do is talk with him about a straight-up plea and go over that possibility with him.
Is there a suspended sentence, like a 3-year probation with suspended 24 months? or
Judge,
something?
he's not going to be able to do probation because there were rules in place for him to not break the law, and he broke the law.
All right, what's the bond hearing motion?
All right, so Judge, he's been incarcerated this time since June 1st of '24. He's only got a $2,000 bond, but he can't make it. He's being asked to be allowed to sign his bond. He's currently unemployed, but he resides with his mother, Cara Bain, and he's lived in this area all his life and has substantial ties to the community.
And this bond is what?
His bond currently on the case that we're seeking a bond reduction on is $2,000. He's already got an ROR on the remaining count of the other case.
Cash or professional?
That's what it currently is, Judge, is
All right, you put
$2,000.
up $200 and get out, so I'm not going to change the bond.
Thank you, Judge.
All right, Judge.
So did we continue to the 8th
No, you won't come back until the 26th.
of August?
Yeah.
All right, yeah, I'm not wanting to take.
Okay. Oh, Dwayne Moore. I'm sorry, I was looking at Jeffrey Keith Moore. Judge Dwayne Moore, you do have a report from DCF on him. They're recommending that he remain there at the hospital. He's apparently making reasonable progress, but he's not ready to be released at this point.
All right.
So what I'd suggest is we set another 6-month date.
No objection.
All right, what's a court date 6 months out?
Madam Clerk, do you have a date for us?
sometime in January, like January 25th.
What we could do is set for the last date that we have, and by that point, either continue it, or if we have a report already.
We got court December 26th. We're not having court December 26th, are we?
I'd rather not,
Do we have any cases?
Judge.
There's no cases?
I think we have a court date after every holiday.
December 5th.
Okay. Thank you, Judge.
The
I
only
believe
one
my
that would
secretary
come
will
to
do the order.
only one that come to December 26th is Mr. Barry, because he doesn't get any toys on. He's always in a grumpy mood, so he'd be happy to come to court. All right, Jeffrey Keith Strouser Moore.
Judge, this is another motion for bond reduction. Mr. Moore was originally released on one of the cases and then had his bond revoked. He's been incarcerated since June 11th. His bond was revoked in 24 CF 1046. He has a $2,000 bond in 24 CF 1357 and a $1,000 bond in 24 CF 1358. He's requesting a signature bond in all his cases. He was employed with Walmart, but believes that he no longer has that position due to being in jail, but he does believe he can become employed at Taco Bell if released. He will reside at 5707 Fairfield Road, or Fairchild Road in Crestview, and has lived in this area for 20 years.
His bond was revoked for some reason?
It was, Judge, he indicates that he was told that he could still have contact with the family, and he went over there, but apparently there were pets there, and he's not supposed to be around the pets. I don't think there's an allegation he was left alone with them or anything like that. But then when he was arrested and taken to jail, they found contraband on him, and that resulted in the other two cases.
What does the state say?
So I have a report from Officer Tiffany Lacroix. Said Jeffrey Moore was released on bond for charges of aggravated animal cruelty. Defendant was released on a $35,000 cash or professional bond with pretrial supervision on 11/7/2023. The defendant has violated the following court-ordered conditions of his bond. Within 24 hours of his release from jail, and each Tuesday thereafter, report to Okaloosa County Pretrial Service as scheduled. No contact with the victim, not to be within 500 feet of the victim's home, vehicle, employer, place frequented, and notify pretrial of any changes to the address, contact number, so on and so forth. How he violated the specific facts are per Crestview Police Department, incident report number CPD 24 OFF 001850, submitted to pretrial service. The defendant was found to be in direct contact and possession of domestic animals that were located in the same hotel room the defendant was found to be residing. So the victim in the case, believe it or not, is a cat, and he was with the same cat. So specifically told not to be with that cat.
Okay. Judge?
The animal involved in the case was being returned by Animal Services. When it was discovered the defendant was also staying in the same room and the other domestic animals were seen roaming freely around the same room as the defendant. These actions are a direct violation of his current bond and pretrial release conditions. So we have put conditions in place to ensure the defendant's conduct is that what we want of somebody who's not incarcerated. And he has failed to do so. He's violated the specific conditions of his bond. And I believe the judge...
Bond on 24 CF 1046.
1046 is the aggravated animal cruelty case, and the bond is $35,000 cash or professional, which has been revoked since.
Judge, if you give me a chance to be heard.
He wants to say something.
Your Honor, I did not, there was a huge miscommunication whenever it came to all this. Whenever I first got on pretrial, I had contacted my pretrial officer and I had asked her, I said, me and the mother, we got kids together and everything. I said, as long as the cats, because me and the mother are still together, I was like, as long as the cats are not in the same room, because we got kids together, they were still going to school around that time. I was like, is it okay if I can, still go over there to, help make sure my kids get on the bus and stuff like that? She advised me, she said yes, as long as I was
Objection,
around.
Judge. This is hearsay.
I have no
Self-serving
reason, I have no
hearsay.
reason to lie.
Statement by a party opponent, theoretically.
And needless to say, whenever she had said that, I was under the impression that I was okay to go over there to just take care of my kids. I wasn't even necessarily staying over there. I got proof that I was staying at other places. I was just over there at the time because I was helping take care of my kids. Whenever I found out that I could not be around animals at all, period, because, that's what the thing had said, and I was told a little bit something different. The mother of the kid, my kids, she had actually got rid of the animals and had them go stay somewhere else. So whenever I got arrested, there was no animals there because I wasn't even trying to violate pretrial or anything like that. Had I have known that I could not be around animals at all, I would have never done it to begin with because I'm not the type of person to just be violating and doing stupid stuff. Like I got.
A prior record?
No, Judge, he doesn't.
I haven't been in trouble in years. Sorry.
You haven't been in trouble for years?
I have not been in trouble in years. Like it's been a
I
while
should have
since
a
I've been
copy
in
of
trouble.
his score sheet here somewhere if the
Who set
state's
the
provided it.
$35,000 bond?
Judge, that would have been the first appearance, Judge. And at the time, they were thinking this cat had been very seriously injured. Since then, we've gotten a copy of the veterinary report. If I can, and I sent this information to the state via email back on July 1st. A review of the veterinary report, particularly page 5 of 16, radiographs, those are x-rays, no abnormalities seen, which means no fractures. Patient not showing signs of head trauma at this time. Then a little bit later on, the initials JB, no sign of head trauma. Page 15, neurological, normal.
How long has he been how long has he been in jail?
He's been in jail since, I believe, the 11th, Judge. I've got it in my motion.
11th of what?
July. Yeah, or June 11th, 2024.
And the allegations, the reason it's filed as an aggravated animal cruelty is the allegations are his son watched the defendant like slinging the cat in the bathroom of the hotel room, which would likely cause serious bodily injury.
Sorry,
But
Judge.
what the defense is stating,
Remember, Mr. Williams, these inmates are sensitive.
Yes, sir.
Okay, they're sensitive.
but what Mr. Williams is stating, as far as the veterinarian report, it is correct that the cat is in good health now, is with the owner.
All right, well, what I'm going to do is,
And Judge, we obviously dispute the facts.
what I'm going to do is change his bond to on 24 CF 1357. He has no failure to appears, right?
That's correct, Judge.
No, Judge.
2,000 signature on 24 CF 1358, 1,000 signature, and on 24 CF 1045 or 6, is it 5? 6. 24 CF 2000. For some reason, I'm 24 CF 1046. I think correct.
Yes, Judge.
3,500 signature.
And Judge, we would object to that bond. Since he received a cashier professional on the first time and he violated, he should still receive a cashier professional.
Okay. 3,500 signature.
Thank you, Judge.
And
Thank you, Judge.
no contact with cats
Any domesticated animals.
or any animal, domestic animal. Yes.
What
You
about,
just won. You want to take a chance on unwinning?
kids go and stuff, like, as long as I'm not in the room, if I'm outside of the room, is that okay? Or,
Judge, one of his issues, he's got a
Okay.
dependence, either an injunction or some sort of family law case pending. So that's something that I don't think the court's imposed any restrictions on him seeing his kids, but he'll have to address anything dealing with the family law case in front of that family law judge, and you've got a Zoom hearing that's already scheduled on that.
Yeah, I can't let you go in front of your kids or whatever it is if another judge has said you can't go. All right?
All right, so he's not put any
You want
restriction on
to
you
stay
being
in
around
jail
your
and
kids.
make sure you don't get around them, but
no,
I'm letting you out on signature. Don't go around them. Obey whatever the other judge said do, okay?
Yes, sir.
If they say you can't be around them, you have to get that judge to give you permission, okay?
Thank you.
Okay.
All right.
I think I got your paperwork here. I tell you what, just hang on to him for a minute so I can get his paperwork back to him. He handed me some, did you grab those papers already?
No.
Okay. Judge, I think I only have one more case.
All right, Amanda Lee Naderos.
Here we go. Hey, Stephen. This is his paperwork. Over next to me. Judge, I'm going to enter a denial for her, and we'll need to set her for another hearing. We're looking into some alternative sentencing options.
All right, this is 21 CF 115, State versus Amanda Lee Naderos. What about,
Judge, part of that's going to be looking at different places that she can go. I did send an email off on it already, but I'm going to suggest we place it out further than 8/8.
what about August 29th? Do we have?
I think that'll be sufficient, Judge.
Okay.
Okay.
All right, thank you. All right, anybody else? Mr. Gibbs, you got
Your Honor, I
something?
would like to call Mr. Franklin that we sentenced earlier. I just wanted to make the record clear that he has 180 days to pay his court costs.
Okay.
Got no objection to that.
All right, Mr. Franklin, is that right?
Judge, it was 24 CF 1283. It's number 9 on my document.
Ronald
Judge.
Dale Franklin on 24 CF 1283. I'll give him 180 days to pay his court costs, or they go to a judgment.
Thank you, Judge.
Thank you.
Good luck. That's all I have. Thank you.
What else we got? Is that it?
I'm done.
Thank you, Judge.
Thank you, Judge.
Report and the state stipulation and defense motion. All right, he's competent to proceed.
Your Honor, we have reached an agreement in this matter, if I may approach.
All right. State of Florida versus Richard Fred Pericas?
Perikas, sir.
Pericas, 20 CF 3166, 20 CF 3168. Mr. Pericas, would you please raise your right hand to be sworn? You swear the testimony you give for is court's the truth, so help you God.
Yes, sir.
You want to enter a no contest plea one count in each case of failure to register. Is that correct?
No, Your Honor, it was, actually, the
excuse me.
state's going to dismiss one case.
Right. You want to enter a plea on 20 CF 3168 to failure to register, and the state's going to drop the charges on 20 CF 3166, correct? All right, so you want to enter a no contest plea to that one charge?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea?
Yes, Your Honor.
Did anyone force you or threaten you to enter this plea?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Absolutely not.
Are you happy with the work Ms. Rivers done for you on your case?
She's absolutely fantastic, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. The state's going to dismiss the charges in 20 CF 3166. Let's see, on 20 CF 3168, court's going to judge you guilty, sentence you to 34.8 months Department of Corrections with credit for 34.8 months. And 415 court costs, $100 cost of prosecution, $150 PD fees. I'll give you 180 days to pay that, or it goes to a judgment adjudicated guilty.
And Your Honor, would you authorize his release from the Okaloosa County Jail? Because
Yeah,
it's credit time served, but the state does want it to list that he did have to do.
Yes, Your Honor, we have agreed that Mr. Perseus has.
Perikas.
Perikas, I'm sorry, sir.
You're fine,
Perikas.
ma'am. God bless you.
Sir, we do agree that the time that he served, previously has served would amount to the 34.8 months, so we would not have any objection to the court ordering his release based on the time that's already in.
All right.
Your Honor.
You'll be.
Can I be released from the jail on Monday?
Nope, we're gonna go ahead and do it.
Monday, I never heard people that I'm about ready to release you today, but you don't want to get out today. You want to get out in a few more days.
Well, it allowed me to go to the facilities with my family. My family lives up in Tallahassee, and my niece is a school teacher, and so she'd have to get off work to come down, pick me up, drive me to get registered.
I don't know if I can. I see. I don't have the authority to say you've served your time, but I'm gonna let you stay in our Okaloosa County Hotel jail. It's not a hotel. You got to go. If you finish your time, you got to go. Okay.
And Your
Thank
Honor,
you, Your
I'm going
Honor.
to talk to him. I'm just going to ask Mr. Williams to have him in the interview room, and I'm going to update him in
All right.
conversations about the family.
All right. We'll try to help him out, and I can't make you serve more time than you're supposed to.
Okay.
Okay.
Thank you, sir. I appreciate that.
All right.
And if y'all
God
could-
bless you, Your Honor.
Thank you.
All right, he's going to have to do fingerprints, I think, and then you're going to meet me in the interview
All
room,
right,
okay?
Miss Lisa. God bless you.
Uh-huh.
All right.
Your Honor, thank you again.
All right. All right. Good luck to you. Thank you.
Back here anymore.
All right. Very good. This Mr. Is it Dixon?
Yes.
Keem Dixon, okay. This 2018 CF 2695. And he looks like he doesn't have an attorney. Violation of probation. Is this a VOP arraignment?
I believe so, Judge. He has a VOP and a new law violation. So we would ask for the new law to track with the VOP.
How about let me appoint you an attorney, Mr. Dixon, to represent you on a violation of probation? You're here for arraignment. Is there some type of offer for him?
Not at the moment, Judge.
Let me appoint an attorney to help you. Maybe they can get a deal for you or take it to trial or whatever. So I'll appoint the public defender to represent you on these cases.
Your Honor, now that we've been appointed, we'll enter denial and ask to set this for September 5th.
All right. Set it for September 5th.
No objection.
All right, thank you, sir.
I do, Your Honor. I have a couple, if I may.
All right.
Your Honor, the first I have out of custody is going to be Ms. Frances Diamond. Your Honor, Ms. Diamond is present and approaching. Judge, we've reached an agreement for Ms. Diamond to enter a plea and go into PTI.
Francis Diamond, 24 CF 1407.
Yes, Your Honor.
Ms. Diamond, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
Is she going to enter a plea to this charge?
Yes, Your Honor. She'll enter a plea to the introduction of contraband charge. Probation signing the PTI agreement now, and I'll have that for the court.
And Judge, since the defendant is entering a plea for the PTI, the state has no objection to return the evidence that was seized.
Your Honor, if I may approach.
All right, you want to enter a plea of no contest, introduction of contraband into a county detention facility. Is that, that's a third-degree felony? I believe it's a third degree, isn't it not, Mr.?
It's a third degree, Judge.
So you want to enter a no contest plea to those charges, correct?
Yes, I do, sir.
Do you understand the rights you're waiving by entering this plea? Are you under the influence of any drugs or medication to prevent you from knowing what you're doing here today? Has anyone forced you or threatened you to enter this plea?
No, Your Honor.
You happy with the work Mr. Gibbs done for you on the case?
Yes, sir.
So if you complete this agreement with the state, the charges will be dropped. And if you don't, you're going to be sentenced according to what's listed in this agreement. You understand that?
Yes, sir.
And the court will have no problem or will allow the evidence that was gathered against her to be returned. Is that what the state was asking?
Yes, Judge.
Okay. All right. Anything further?
No, Your Honor. We may submit an order to that effect if the sheriff's office gives her any trouble.
Yeah, give me an order. Here's the agreement. Do you need it back?
Thank you, Judge. So you'll just meet with them. Yeah, you've done a good job.
All right. You got another one, Mr. Gibbs?
Yes, Your Honor. The next person I have out of custody is going to be Mr. Horace Durden.
Horace James?
Yes, Your Honor.
All right, Mr. Durden. Okay.
Your Honor, we're here on a motion to modify Mr. Durden's bond or bond conditions. Judge, he is currently on a GPS monitor for his pretrial release conditions. He's been on that monitor since the inception of this case back in 2022. He had already posted a $68,500 professional bond. The condition was that he's on a GPS monitor. We are working on a deposition of one last witness in this case. We have been trying to move this case to trial. We've moved it 2 or 3 times now to trial. It's gotten continued for other reasons. He's completed a parenting class through DCF as required in a previous case number in 22 CF 178. So the case is just getting old. He also works for Anderson Columbia. I'm sorry. Yeah. He's completed his anger management. He also works for Anderson Columbia, Judge, and that's construction, it's concrete work, and it also leads to a risk that the GPS device may become damaged inadvertently despite his best efforts. So we're just asking that the court order that he no longer needs to wear the GPS monitor while the case is pending.
State.
The state has no objection to removing the GPS monitor.
Mr. Durden has always showed up for court. He's always been prepared, ready to go. He's been very respectful. He's honored his bond agreement, so I'm going to order the GPS removed.
Thank you, Your Honor.
Thank you.
Otherwise, he should be set for pretrial on the 26th.
Okay, thank you, sir.
Thank you, Judge. We'll send an order.
Okay.
Get an appointment. Yeah, go ahead. You'll meet with pretrial to do that. I'll get an order. Judge, the only other person I believe that I have out of custody this morning is going to be Mr. Nicholas Adkins.
Nicholas Atkins.
Oh, there he is.
All
I
right.
completely
Nick-
saw through you there.
This is 24 CF 1457, Nicholas Atkins.
Yes, Your Honor. I filed a motion to strike the probable cause affidavit from pretrial supervision and vacate this court's order revoking his bond and commanding his arrest. The affidavit from pretrial was not sent to me at all, nor was I even contacted about it. The court entered an order 20 minutes after it was filed to revoke his bond and command his arrest. He's already been found not competent to proceed in 2 case numbers, 23 CF 373, 23 CF 531, both of which are pending still before this court. He's on conditional release, was on conditional release with Mr. John Barnes, who is, of course, no longer employed. I know the court administration is working on filling that position. He's been in contact with us. In fact, he has an appointment with Dr. Zeman in our office on Monday to have a competency evaluation, which was specially done because of his transportation issues. His mother is present in court as well and has information that he has been going to Bridgeway. We're simply asking the court to vacate its order revoking his bond and commanding his arrest so that we can continue him on conditional release.
Trying to remember why I revoked it.
So it's a dead animal. The facts of the case are he was trying to go to the store. It was really hot outside. His family told him not to take the dog because it's too hot and he's gotten in trouble before. That's why he's on pretrial release. It's for cruelty to animals. So, long story short, the dog passed away because of overexertion. And he didn't have water with him. He wasn't prepared. So there was probable cause for the to revoke his bond. Furthermore, from the record, he pled no contest to a misdemeanor recently after he was found incompetent to proceed.
And I would object to that, Judge, just because that was in a different court. That was in front of Judge Ward, even if he was represented by
All
somebody.
right,
in
I'm
our
going to make a
office.
condition. He's not to have any contact with animals and reinstate.
That was already a condition, Judge. He was already supposed to not have contact with the animals, and now a canine is no longer with us. It's cruel to have this individual be out and harming living
this
creatures.
bond? Somebody out there wants to.
Additionally, Your Honor, the affidavit that's here that the court filed in order to revoke his bond and command his arrest, the affidavit from pretrial services alleges that Mr. Atkins was not checking in with pretrial supervision after the arrest on this case, this 2024 case number. Typically, what pretrial supervision does is they will actually reach out to our office and ask that we try to contact the defendant, try to contact them, try to get them to get in contact with pretrial supervision, and that was not done here. Typically it is, but it was not done here. Nobody reached out to my office, to myself, to try to
Some
get
type
contact.
of comment, I'm going to vacate it, and you're not to have contact with animals. Is that clear?
Yes, sir, Judge.
I don't know how much clearer I'm going to make it. I'm going to put you in jail next time.
Yes, sir, I understand.
Thank you, Your
I
Honor.
understand, yes, sir, Judge.
I'll send the court an order.
All right,
Otherwise, he's set for the 26th, Judge.
all right.
Yes, sir.
Next.
Yes, I'm ready for my inmates. Your Honor, Tim Gibbs on behalf of Mr. Nicholas Bennett. Judge, this is 22 CF 1884. He also has 24 CF 1111 and 24 CF 1112 new laws. Judge, we'll ask to set these for August 26th for pretrial. We're working on getting referrals in for treatment. We should have them by then.
All right, thank you. August 26th.
Thank you, Judge. Yeah, so we'll get them done. Your Honor, Tim Gibbs, on behalf of Mr. Brown, 22 CF 1911, 23 CF 2193. I believe the court filed an order with relieving us from Mr. Brown's cases and appointing regional conflict counsel.
All right, she's not here, right? One, I think.
She's ran a juvenile court.
She's what?
Juvenile court.
Oh, we'll bring Mr. Brown back in a few minutes.
Yes, sir.
Thank you.
Cordell?
Your Honor, Tim Gibbs on behalf of Mr. James Cardell. Judge, this is case numbers 24 CF 1561. Judge, we're here for a motion to reduce modifier set bond. I'm trying to pull that up on my laptop real quick so I can advise the court. Your Honor, Mr. Cardell has been incarcerated since July 3rd of this year. He has a total bond right now of $12,000 cash or professional, $10,000 on count 1, $2,000 on count 2. He's unable to make that bond, Judge. He's lived in the area for 10 years, would be living locally. The allegations in this case, Judge, are that Mr. Cardell was the driver of an RV while they went to the business Inn Dine in South Crestview into the parking lot. Apparently were caught on security camera. 2 people got out of the RV, stole some items, got back into the RV. At some point while that was happening, Mr. Cardell actually tried to reverse the RV to prevent these 2 people from getting back into the RV, indicating that he was unaware that they were trying to steal things. They were otherwise trying to go and scrap through the dumpster to make some kind of living through there, but without having to steal. If anything, Mr. Cardell was a driver and was duped into being part of such a criminal enterprise, if there is such a thing. He's unable to make his bond, Judge. He's never missed court. We're asking that the court modify his bond to ROR signature. My understanding, and as been reported to him, is that others have been going and ransacking his RV, as well as have stolen his motorcycle. He has been, victims of those crimes while he's been incarcerated, trying to handle these charges. And so we're asking the court to impose an ROR signature bond.
So I don't know how that story would get into trial, but we're going to object to a bond modification or reduction. The defendant is charged with burglary of an occupied structure. There's video surveillance and witnesses available. Defendant scores a minimum presumptive DOC sentence of 76 months. The offer is 80 months. DOC is passed. Shows violent crimes and he's a danger to the community. Also a flight risk. His pass includes robbery by sudden snatching, grand theft, burglary of unoccupied structure, worthless check, burglary of structure with while armed, aggravated
All right, the
assault.
court finds it's reasonable based on his past record and potential flight risk. Thank you.
Otherwise, Your Honor, he's on for arraignment this afternoon. We'll enter a not guilty plea request, 15 days for any pre-arraignment
I'll
motions.
see if you can work this out.
We will. I don't know when he's set for pretrial. If we can do the 26th, that's fine with us.
Okay.
Yes, we'll go ahead and enter a not guilty plea for
All
him.
right, thank you. Hopefully you can get your case worked out. Thank you, sir.
Your Honor, Tim Gibbs on behalf of Mr. Jason Christmas. Judge, this is 21 CF 1987. We may have a resolution if I can have just one moment.
All right. Mr. Christmas, would you please raise your right hand to be sworn?
Yes, sir.
You swear the testimony you give before this court is true, so help you God?
Your Honor.
Thank you.
Your Honor, if we could just pass Mr. Christmas briefly, I'm going to write up his plea agreement.
Okay.
Just sit right there. It's going to take me 2 seconds. It's going to take me 2 seconds. Yeah.
Mr. Powell?
Clark Trivet, Judge.
This is 21 CF 2024, Clark Andrew Trivet.
Judge, we've got an agreement.
I'm trying to sort it out right now. Mr. Trivet, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
You want to enter a no contest plea to charge of failure to register? Is that correct, Mr. Powell?
Yes, sir, failure to report the electronic mail address.
All right, failure to report electronic mail address, and that's a third-degree felony. You understand that?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drug to prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Powell has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you 90 days county jail. Restore probation, community control with original terms and conditions. Complete 100 hours community service. Standard fines and court costs. And am I giving him credit for time served, or is it a new night? And credit
Since he
for
got in jail.
credit for time served.
Since the arrest on the VOP, Your Honor, was our agreement.
Since the arrest on the VOP, do you happen to know that date?
No, I don't have it handy, Your Honor. We'll let the jail calculate that.
All right. Well, I'm giving you credit for time served since the arrest on the VOP.
I think it was June 17th, Judge.
June. Okay, well, I'm giving you credit for that time. Okay?
That's all I got, Judge.
Thank you.
And Your Honor, I'll get the court the score sheet by the end of the day.
All right, okay.
Your Honor, on Mr. Trivett, just so the jail knows, he has to be hooked up on GPS prior to release, and we request the GPS fee be $1 a day.
All right.
Yeah, I just need to talk to him just a second.
That's all I got, Judge.
All right.
I'm ready for Mr. Christmas, Your Honor.
All right.
Your Honor, Tim Gibbs on behalf of Mr. Jason Christmas, recalling him in 21 CF 1987. All right, so, terminate, 60 days, credit for time served. Fees have to be assessed, money to pay. What to do to admit today? Just sign right there for me. Today's date, please. August 8th. If I may approach. Score sheet included, Judge. No objection. This is now working out there.
Mr. Christmas, you want to admit that you violated community control?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Did you sign that form just now?
Oh, yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, Your Honor.
Court finds admission freely and voluntarily entered. Court accepts it, revokes and terminates probation. Sends you to 60 days Okaloosa County Jail with credit for time served, $100 VOP fee, $150 PD fee, money due within 180 days or it goes to collections, and adjudicated guilty, and that's it, I think. How much time you got served already?
He's close. Got a week or two, Judge, I think.
All right, so, and the court orders you not to break the law in the future, okay?
Yes, sir.
Thank you, Your Honor.
Thank you. They listen to that, Mr. Russell.
Yes, sir.
They obey.
Worth a try, Judge.
Your Honor, Tim Gibbs on behalf of Mr. Shannon Gallardo. Judge, this is 24 CF 545 and 20 CF 128. Your Honor, he'd like to enter an admission to the bench on this case and set sentencing for August 29th.
No objection.
This is 20 CF 128, State versus Shannon Gallardo. Mr. Gallardo, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
You want to admit that you violated, is it probation or community control?
I believe it's two probations, Judge, two cases.
So you want to admit, admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission? Yes, sir. Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing
No,
what
sir.
you're doing here today?
No,
Are
sir.
you happy with the work Mr. Gibbs done for you on your case?
Yes, sir.
You know, there's no plea bargain on the case, and I can give you whatever sentence is legal, a maximum or minimum. I don't know, I haven't heard yet what they're asking for, but
Yes, sir.
it's a plea to the bench. You understand that?
Yes, sir.
All right, so the court finds the plea is freely and voluntarily entered. The court accepts it. We'll set the sentencing for what day?
August 29th, Your Honor.
August 29th. Okay?
That's fine for the morning or the afternoon. That's the court's preference.
Make it in the morning.
That's fine, Judge. Thank you.
Okay, thank you.
Okay, thank you.
Morning, Judge.
This is Brown right here, right? Okay, this is the shopping bit. Could you just get off, Brown? And now it's yours.
Yes, Your Honor, Jennifer Flowers with RCC on behalf of Jeffrey Brown. I believe I was just appointed. It's a VOP.
Yeah, there's new laws and VOPs.
And the offer is 10 years DOC at the moment.
I believe at this time we'd like to enter a denial on the VOPs.
Okay.
And I'm sure a not guilty plea has already been filed on the
All right.
new laws and asked them to be tracked together.
We'll set him for October 28th.
Thank you.
All right, thank you.
I'll be able to see you soon, okay? Your Honor, this is Mike Kelton Lett. We keep setting him on these miscellaneous dockets. We have an amended offer from the state that Mr. Lett is not rejecting. We just haven't had the proper time to go over it in full detail. I believe there's no objection from the state to setting this on the 29th for entry of a plea.
All right, McKelton Lett, okay, good. I hope it gets resolved, Mr. Lett, okay? All right, so August 29th, I think. August 29th,
We can do that.
okay?
Okay? Thank you, Judge.
Thank you.
And we'll have Strauss. Strauss.
Your Honor, this is Robert James Strauss, Jennifer Flowers with RCC on his behalf, in 21 CF 247 and 20 CF 3247. These are both VOPs. Your Honor, we've reached an agreement with the state. He's going to be admitting the violation, and the agreement is that probation would be revoked and terminated, and he be sentenced to 36 months in the Department of Corrections, which was the suspended sentence in the original plea agreement. If I may approach.
That is the state's agreement, Your Honor. We are asking the court to vacate the 36 months suspended.
All right. Mr. Strauss, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
This is 21 CF 247, 20 CF 3247. State versus Robert Strauss. You want to admit that you violated probation, correct?
Yes, sir.
Are you aware of the rights you're waiving by entering this submission?
Yes, sir.
Anyone force you or threaten you to enter this submission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers done for you on your case?
Yes, sir.
Court finds admissions free and voluntarily entered. Court accepts it. Judge you guilty, revoke and terminate probation. Impose 36 months Department of Corrections sentence, credit for time served, $150 cost of defense, $100 VOP fee, 2 collections. How much time have you got served already? How much time you got in the jail, you know?
I guess around 11 months to a year, something like that, I think.
All right, well, you got a good portion of it served because I'm giving you credit for time served, so.
Yes, sir.
All right, okay, thank you.
Thank you.
Do I need a score sheet on this, or there was
I
one?
will get the court one, Your Honor.
Okay. All right, Cordell Thomas.
Yes, Your Honor, Jennifer Flowers with RCC on behalf of Cordell Thomas. We're set today for a motion to dismiss hearing 24 CF 24. I filed a motion to dismiss based on basically lack of reasonable suspicion to detain Mr. Thomas, and the state has filed a traverse. They denied specifically the facts in paragraph 3, 4, and 5. However, the state did not make clear in their traverse just that they were denying the full paragraphs, I guess, in their entirety. These are quotations taken from the 911 call, as well as quotations taken from a deposition that was conducted, and quotations taken specifically from the arrest report. It's an absolutely accurate representation of the facts in this case, and the point that the defense is arguing is that when Officer Axelson with CPD approached Mr. Thomas, she only had a description of a black, thin, tall male with a certain color T-shirt on, and that she was responding to a disturbance, that someone's phone had been stolen. On the 911 call, it's her cousin stole her phone. She never said that this was her cousin. She never alleged that Mr. Thomas stole any phone. She alleged on the 911 call that a black male was following her aggressively in her vehicle. When the officer approached Mr. Thomas, she immediately told him he was being detained. And it's just the defense's argument that at that time there was no reasonable suspicion to detain him. And I provided case law, pretty extensive case law that was very on point, Brown versus State, that the state has to prove, obviously, by the jury instructions, that the defendant knowingly and willingly resisted or obstructed, and that number 2, that's the one at issue here, that at the time the victim was engaged in the execution of a legal process or execution of a legal duty. And Brown versus State, the court found that the officers did not have reasonable suspicion to detain the defendant in that case. They defined reasonable suspicion as particularized and objective basis for suspecting the person stopped of criminal activity. Ms. Axelson stated with particularity in her deposition that she observed no criminal activity, and that the criminal activity she was responding to was a disturbance, a potential fight, but no allegation of a fight. Similar to the facts in Brown, in that case, in State versus Brown, which is 298 Southern 3D 716, the deputies responded to a 911 call in that case by a hotel owner alleging that a disturbance had occurred, and were provided a description of a male subject. Deputies approached the defendant because he fit the description provided by the 911 caller, also similar to our case. The defendant in that case became agitated, irate, and tried to terminate the encounter with the deputies by attempting to walk away. The deputies ordered him to stop and informed the defendant he was being detained for an investigation. When this defendant did not comply, deputies grabbed the defendant's arms in an attempt to handcuff him. The defendant began swinging his arms to avoid being cuffed. In the struggle, the defendant hit one of the deputies' mouths with his elbow. Deputies then tased the defendant, who was eventually arrested and charged with 2 counts of battery on a law enforcement officer and 1 count of resisting an officer with violence. The deputy admitted at trial that when they ordered the defendant to stop, they had been unsure whether a crime had been committed, understanding only that a disturbance had taken place. The second DCA reversed the defendant's conviction, holding that the trial court erred in denying defendant's motion for acquittal because the state did not meet the lawful execution element of the crime for which he was charged. The court also stated of importance that a refusal to cooperate without more does not furnish a minimal level of objective justification needed for a detention or seizure. Similarly, in Davis versus State, the court, the Second District Court of Appeal reached a similar conclusion with similar fact evidence. In that case, 2 officers were dispatched to a restaurant to investigate a suspicious incident. The court in Davis stated that information the deputies learned from the 911 call lacked details about the nature of the incident that they were sent to investigate, and that although deputies were able to identify the defendant matched the description of the subject involved in the, quote, disturbance, they were no better informed by the nature of the disturbance and had no reasonable basis to suspect the defendant had been involved in any criminal activity. The facts are almost identical in this case. There was an incident, a 911 caller called in that she was with a relative whose phone had been stolen at a certain hotel. She did not allege who had taken the phone, and it ended up being, they found out later in the investigation, it was a cousin that had taken a phone. It was a family dispute, and basically,
nothing to do with me.
And the only information that the deputy had at the time she approached Mr. Thomas was that he matched the description of this person involved in a disturbance. I will also say that there were three black males, one of which she described as tall and following her aggressively on foot. She was in a vehicle. This is not criminal activity.
They picked me out of the lineup. I'm sorry.
Your attorney's making all these great arguments and you keep interrupting her.
I'm sorry, sir.
And
I apologize.
furthermore, Officer Axelson, this was more of a citizen contact situation, had she approached Mr. Thomas just to ask some questions, and he had the right to walk away. She told him he was detained, and she had no reasonable suspicion that she was investigating a disturbance, but similar as in these cases, she had no facts that Mr. Thomas was involved in any sort of criminal activity. And for that reason, he then, as in these cases, became irate because he didn't want to be arrested. He said, I haven't done anything. And that's when he was eventually charged with resisting with violence. He was tased. And it is our argument that it was an illegal detention, illegal arrest, and that the state cannot prove the second element of the offense which was that the officer was engaged in illegal duty at that time. So we're asking the court to dismiss the case.
Judge, the differences between the cases that were cited and this case is that there was a crime that was alleged. It was a party identified themselves, so it was not an anonymous tip. They described exactly the defendant, and when Officer Axelson was detaining the defendant based on her reasonable articulable suspicion based off of the description provided to her or to dispatch, the defendant spontaneously uttered, "I don't know anything about no phone." So that just adds this articulation that he was a suspect of a crime, and our cops or our deputies that are on the road, we hire them to investigate crimes. So he was, or she was, in a lawful duty. She was investigating a crime. Furthermore, the state filed a sworn to traverse, and I don't believe that the court has an alternative other than to deny going into the facts and the circumstances of the case, or for a later date, possibly for a motion to suppress evidence, but as a motion to dismiss, I believe the state has met its obligation and burden.
I think that traverse has to be material facts. And the court checked on all that case law and found it remarkably similar to this situation as alleged in the motion. So I'm going to grant the motion to dismiss. Prepare me a detailed order, Ms. Flowers, and I'm ordering you to stay out of trouble.
Yes, sir.
Thank you.
Your Honor.
Just,
Okay.
thank you, Your Honor.
What is that? I got to put about the bond. But I got a bond. For a reasonable bond for that, remember?
Thank you, Your Honor.
Thank you.
So that's over with. All right.
Thank you.
All right, thank you, Ms. Flowers. Thank you, Your Honor.
Thank you.
I believe that's all I have on today's docket. If anybody needs.
I've got Mr. Williams lined up. I
Why
don't
can't-
see- Is it Mr. Rainey? No, sir. Okay, I'm here for Mr. Henderson. I don't think Mr. Rainey's coming today, because this is just on one count that was merged into another case, so. I know you said you were waiting on other attorneys. You both got one. I thought so. I checked Your Honor, I checked the clerk's site.
Come on up. I can't hear you back there. All right, what was your name?
Dustin Harsher, Your Honor. I'm here on behalf of Tony Henderson for Anthony Miles. We were scheduled for a motion to dismiss hearing this morning. I ran into some issues, obviously, with the, there was a consolidation. Wait till Mr. Miles gets here. And I spoke with Mr. Miles at the jail this morning, Your Honor. I do have the motion prepared, and I did get him to sign it after he read through the facts and circumstances. And I spoke with the state this morning, and we would just ask for a one-time continuance of the hearing. I'm not sure when the next hearing date is, but he is scheduled for pretrial conference on the other cases that were consolidated on the 26th.
Well, bring him on the 26th. We'll hear it all at once. How about that?
You'll do that on the 26th?
Yeah.
That'd be great, Your Honor.
All right. Any objection to that?
No objection, Your Honor. Did you say you're gonna set a motion on that day too? Did I miss that? It's just a pretrial conference, right?
It's set for pretrial conference on the 26th, Your Honor. I just want to be clear.
Okay, we'll hear it on the miscellaneous August 29th. It's just 3 days later.
Thank you, Your Honor. That's fine. I just
That
didn't
works.
wanna take the court's
Yeah.
time because it might be.
Yeah, we
on
were
the
pretty
holiday.
jam-packed on the we'll make it the 29th.
29th, that works,
So-
Your Honor. And
More
just
time for
just to
you.
be clear, the motion to dismiss is just on the one count that pertains to the case that Mr. Henderson was on.
All right.
Thank you, Your
and
Honor.
I'll get back with you as soon as I see the motion as well.
All right, thank you.
Okay. That's just what I thought about. We'll just take it.
I got you. Okay.
Thank you, Your Honor. May I be excused?
Yes, thank you.
I'll get you that letter.
Oh, thank you.
Judge, this is Shaquem Hall. He has actually two cases. One is a BOP, the other is a new law violation scheduled for September 5th. I'm going to enter denial on the BOP and ask that it track the new law violation. There's not been an information filed on the new law, so I can't arraign him on that as yet.
Okay, this is Shaquem Hall. All right.
Yes, sir.
Okay, we'll set him for what day did you want?
Just have this track with his other case.
August
Let it come in on
26th?
Well, this is a VOP, so he's not going to be arraigned until September 5th. I'm going to ask that you have them tracked together. Just put it on September
Okay.
5th with the arraignment.
All right, we'll do it together. September 5th.
Thank you, Judge.
Thank you, sir.
Okay, and I'll have this filed by then, okay? Judge, this is Jesse Lee Howell. We've got him on a VOP this morning that I've been appointed to. There's also a new law violation set for arraignment this afternoon. I don't know whether looks like an information has been filed on that. I would ask that the VOP track with the new law violation and the court go ahead and arraign him on that and
What is
ascertain
it?
whether he wants the PD on it.
What's the, I don't have the information in front of me.
The charge is introduction of contraband. That's a third-degree felony. And then possession of paraphernalia, first-degree misdemeanor.
You have a case number on that?
I sure do, Judge. It's 24 CF 1537.
All right, Mr. Howe, you're charged with introduction of contraband into a facility and possession of paraphernalia. You want a public defender to represent you, help you on that case? A court-appointed public defender. I believe you just said you're going to plead not guilty and ask for
That's
jury
right.
trial.
That's correct, Judge.
Yeah, we'll set that for, August 26th. How about that?
Judge, we can try that, Judge, see if we can get it all resolved on that date. I don't
Okay.
know what offer the state
Yeah,
will
see if
make.
y'all can work, that should be able to be worked out.
The offer is going to be a year of community control to cover both cases.
A year of community control?
Yeah, house arrest. Do you want me to explain that to you in more detail?
I know my dad was on, I'm familiar. Is there a way I can get it transferred to Georgia? I'm supposed to be moving up there with my mom. But if not, I can find an
That's a
address
little
here
more
in Crestview.
detail, and I can explain that to you. Do you want me to ask the judge to maybe bring you back this afternoon, and I will try to talk with you between now and then?
Yes, sir.
Okay. Let's bring him back by this afternoon.
Because if I don't get out of Crestview, I mean, I'm not saying I'm gonna violate, but I'm homeless here in Crestview, and my mom and them just got a house in Georgia, and they're trying to get me to move up there.
Just talk to Mr. Sprouse, Mr. Williams, and see if there's some way that can, I'm not.
We're gonna figure out a sentence that is going to not set him up for failure.
Right.
Because he's not gonna be able to go to Georgia. I'm getting signs from probation because I think my understanding from the last time is you can transfer like already people on CC, but you can't put them on and then immediately transfer them.
And we would have to investigate his plan, or Georgia would have to investigate his plan anyway.
I don't know that Georgia has CC or anything equivalent to it.
Work out some kind of, maybe a little bit extra regular probation or something.
We'll come up with something,
Probation would
Judge.
be easier to transfer.
Yeah.
I don't know how they're gonna handle community control up there. Would be the same way we did it.
Well, he's in Georgia, he'd be in Georgia living with his mom. Give him perhaps, I don't know I'm not saying anything because I don't know what he did or didn't do, but sometimes sometimes more probation instead of community control works things out.
And Your Honor, my probation officer was having me check in every Monday because I was homeless, so.
Well, we'll bring back this afternoon and see what we can do.
We'll see what we can get worked out for this afternoon. Worst comes to worst, we'll put you on the 26th, okay?
Yes, sir.
All
Yes,
right.
sir. Thank you. Have a good day.
Lindsay?
Over this way, sir.
So before you get started, the state's gonna dismiss the new law violation and the VOPs for
Okay.
Mr. Lentini.
Judge, we'd had him scheduled for a bond hearing this morning. He was also on the VOP docket. The state's just announced they're going to null pros the new law violation and dismiss the VOPs.
Is he on some other type of probation or anything?
Not that I'm aware of, Judge.
We would ask to continue the probation, so we're not gonna terminate the
Well,
probation.
yeah, if you dismiss the VOP, he just stays on probation.
All right, so they're dismissing these charges against you, Mr. Lentini, so finish out the probation you're on, okay? You'll be, I imagine, released today. So finish out whatever you're supposed to do on your other probation, okay?
You
Okay,
guys need
thank
to
you.
talk with him, have a seat, and they'll explain to you what your next steps are, okay? Hey, Patrick, I sent you over an email late yesterday for like 11:29. Are you able to do that?
No.
Okay. What's your
It's,
offer on it, and I'll
two-
make you more aware of it.
Yeah, 2 years DOC.
2 years DOC still? I don't think we're going to be entering a plea on that today.
These are set for a VOP though, these are old.
Yeah, that's fine with me. Judge, we can go ahead and set it on the contested docket. It looks like we're at loggerheads on an offer. I'll talk with Mr. Medina about his options.
What date?
29?
29th is fine.
August
Judge.
29th? Okay, maybe y'all can work it out still.
The only thing that I might not have by then is, on a case like this, I'm going to be looking into the alternative of an inpatient program and present to the court perhaps at sentencing if he's found guilty of VOP, or on a straight-up plea. But I'll know more by the 29th whether or not we can can do that.
All
Worst
right.
comes to worst, I'll continue it.
Okay, thank you.
Okay, sir. Come on out, please, sir.
Yeah.
Go with 24 on him. He's gonna come
24
back
instead
out
of
on
36.
probation. Huh?
Instead of the 36?
Yeah.
24 DOC?
Yeah, he scores under 44, so there's
Yeah,
not a
that's-
guidelines problem.
That's fine.
Okay. Judge, we do have this worked out. They're going to recommend 24 months. Mr. Nitsky, if you'll recall, we discussed that, and I did up basically 2 plea offers for you, gave you one to review so that you'd have it. Let me find my other copy, and I'll write the offer 24 months state prison. There'll be an additional $100 cost of prosecution, $150 public defender fees. Again, that doesn't go to us. And everything that you owe will be sent to collections.
Okay.
Okay? All righty. Did you review the agreement that I gave you yesterday?
Yes.
Okay. If this
Am I
is what you
getting
wanna
any
do.
credit for my time that I've done?
Yeah, you're entitled to credit for time served. Everybody's entitled to credit for time served.
Okay.
Unless you specifically waive it, and we're not waiving it. Okay.
Mr. Nitsky, would you please raise your right hand and be sworn? You swear the testimony you give before this court's the truth, so help you God?
Yes, sir.
Thank you.
Yeah. Do you want to initial it or anything like that? Judge, I found a potential error on the score sheet. We're going to stipulate to the removal of it. And that's a 63-month. Well, wait a minute, I'm maybe mistaken as well. Actually, it looks like what that's coming from is, was there one with a new felony conviction? Because this one is, I don't think is a new felony violation. I think that's where it's coming from. Is that additional?
Yeah. So mark that out, and then it'll be.
Gotcha. All right, Judge, we're getting it worked out here. All right, so Judge, it's going to be a score of 43.3 points. So this is within the range where state prison sentence is a presumptively legal sentence, but not one where it's required.
Right, Mr. Nitsky, you want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this admission?
Yes, sir.
Did anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams done for you on your case?
Yes, sir.
Court finds admission for the involuntarily entered. Court accepts it. Sent Judge G guilty. 24 months. Department of Corrections. Credit for time served. $100 cost of prosecution. $150 PD fee. And that's it.
Credit for time served and
Yeah.
revoke and term, Judge.
Revoke and terminate. Credit for time served. 24 months. Department of Corrections.
Okay, so when I get out of prison, my felony is taken care of, right?
Your felony is taken care of. You're still serving probation on those misdemeanor counts.
Okay.
Thank you.
Thank you. God bless you.
Do you guys need to see him?
Maurice, and outstanding monies to collections, Your Honor?
Yeah.
Judge, on Ms. Lige, we're here on a motion to restore her to bond. She had her bond revoked based on probable cause determination at first appearance by another judge on a misdemeanor charge of domestic violence. That happened on July 8th. On July 23rd, a week or two later, the misdemeanor DV charge was dismissed, and so I'm just asking she be restored to her original bond.
State.
Your Honor, the state would actually object to her being restored to her original bond. Ms. Lash has a history of not appearing for court. She has had several failures to appear. She tends to show up pretty much when she wants to. So we do believe having her in the county jail might facilitate us actually meeting with her and talking to her. There is a non-incarcerative offer being presented to her.
That's correct, Judge. She has an offer for supervision, parenting class, things of that nature. Thus far, she's not wanted to accept that offer. Certainly, I'll talk with her further, but we are trying to get her out of jail at this time.
Well, don't we have court this afternoon? We don't have court this afternoon.
We have arraignments this afternoon, Your Honor, I believe.
Anyone bring her back this afternoon, talk to her about that?
I can go back and see her and lock up. This will be maybe the third person I'll need to see on that, but I can try to do that if you guys can get them over, because arraignments go so fast.
We bring all of the afternoon in one bunch.
We also
Okay.
have pretrial detentions at 12:30.
That'll be one, and then the 1:30 and 2.
Well, then we could set her maybe for 2, and while y'all are doing whatever other hearings you've got at 2, I can talk with her. No, we just have 1? Oh, okay. I'll do my best, Judge.
All right.
Put her on the afternoon train.
Yeah, put her on the afternoon transport list. And what I'll do is I'll talk with you back in the little conference room, okay? And Judge, the bond motion at this time is denied, correct?
Yes.
All right, thank you, sir.
Is Mr. Russell here? Let me see Mr. Russell and Miss Basso up here for just a second.
Okay, as long as it can be edited, then, yeah, I'm fine with that.
Yeah, that's, there's one person that does the honor.
Yeah, it's a big deal. okay. I mean, it's a huge pain in the ass. I've done, like I said, one tree, one like that, a couple of child sex cases years ago. Basically, something else, but it's a huge pain in the ass.
I'm trying. The next one.
Fifteen-minute break.
All rise, please.
We're just taking 15 minutes. Y'all can step out if you want, or stay here. You just wanted to break. That's the way they're called. Then we start talking about it.
Killing time.
Yeah, don't please don't. Yeah, we're not, no, we don't, we weren't discussing the words there. So, yes. Yeah, there's a discussion yesterday will be about the job. So we don't want to. Yeah, we don't want to report it. Okay, so this is shortly now. Jay?
Yeah.
Are you really gonna get everything worked out on the end? Because that's what they've come back for. He's done it.
What you had from the 29th, which was, hang on a second. 24 months probation, no violent contact, parenting class, mental health evaluations, recommended treatment, comply with DCS case plan, court costs $100, the usual. but I had it as straight probation. If it's,
I think she needs the 60, because she's on probation.
all right, so what are you asking for?
But the other conditions are all right, but,
Yeah, I've got, that's what the AG means.
That's what I mean.
Okay.
That sounds good.
All right, I'll run it past her.
And I'll tell you, as soon as I get an answer, let's bring her out one of the others.
Yeah, I'm gonna run over, pick this up off the printer. I'm trying to do one other up, and grab a quick bite and come back. Somebody else is doing first appearances, so. Pre-trial detentions.
When you got off.
Yeah, there are days I want to go back to just getting blood on.
You got the key to both offices. I got a key. I don't know what it is. I've never been to both offices. He goes and goes and tries to find the lady who took his money, cash
Yes.
Then he goes to
She's gotta be. Yeah. It's joint constructive possession, right? There's an example. Yeah, but that would be dominion.
It's really a unique set of circumstances in his life. And it's right in line.
That would be the better answer.
It's hard for me to believe that I wouldn't open up every car before I bought a car. And I've opened up everything. Because I gotta put something in my glove box. And it wasn't enough. Chapstick, my God. Okay. Yeah. My glove box, I have license, registration, and a glove bag. Not the best place for it. If you yeah. But I still have to have. I guess you're right. Yeah. I'm scared of motorcycles. I'm more scared of music.
And they know what Marty had. That's just, let's look at the evidence of close to see where the gun come from.
Reputation.
I'm telling you, it's anything. Be in a situation where I decide, I'm scared of guns, I don't like guns, I could imagine shooting somebody, going through the facts, trying to decide whether or not I had intent, or I was going to be arrested for murder.
Yeah.
On how old?
I guess, I don't know.
Piece of paper. Yeah. August 26th.
Being on vacation.
Or if it comes amended with, like, would they take it?
Thanks.
For pretrial detention, the state relies on 907045C4A, which discusses prior DUIs. We would point out that the he was convicted for reckless, not a DUI, and that is not inside of the 316-193. And that was 15 years ago that reckless conviction occurred. He does have 2 prior DUI convictions, as state noted, but the last one was 38 years ago. He's not a flight risk. He owns and operates his family business. He's a lifelong resident of the community and a property owner. Looking at the record, his Okaloosa pretrial risk assessment score was 0. And there are means for the court to address state's concerns, such as a scram device, GPS, drug alcohol testing, and such. Given that, defense respectfully requests the court deny state's motion for pretrial detention and order bond of a reasonable amount with such conditions of pretrial release as the court deems appropriate.
You say he has 3 times legal limit?
Your Honor, his blood alcohol at the hospital was 236. So if it was serum blood, that's going to convert to approximately a .20. And if it was not serum blood that was taken, we'll find that out later. Then his result would be a .236 based on the unit conversion.
So he had a reckless but 2 other DUIs? Is that
Yes, Your Honor. He has a reckless and 2 DUIs, and one of those DUIs involved a crash, as indicated on the driver's
finds that there is sufficient evidence for no bond detention? All right, these be admitted into evidence.
That's all I have before the court. May I be excused, Your Honor? Thank you.
That's all I have, Your Honor. Thank you.
Next up, we have Watson.
Good afternoon, Judge. Jennifer Flowers with the Office of Regional Conflict on behalf of Tiquan Watson in 24 CF 1838, here for a pretrial detention hearing. Your Honor, Mr. Watson has been charged with 1 count of burglary of conveyance armed and 2 counts of grand theft of a firearm. Mr. Watson is 16 years old. He lives with his mother. For a little background, these charges stem from an incident that occurred back in October of 2023. Case number 23 CF 2515 was a case in which he was charged with firing a firearm in a public place. He entered a plea and was sentenced in that matter back in February of this year and served an 1129 jail sentence. He was released and then rearrested on these charges of burglary and grand theft of a firearm because the officers, the law enforcement, connected the firearm that he shot to be a firearm that had been reported stolen. There are no witnesses to the allegations of burglary or grand theft of a firearm. He denies of committing these particular crimes. It would be a big jump for the state to go from him being in possession of a stolen firearm to that which he's now charged with burglaring a home and stealing these firearms just based on basically solely his possession of the firearm and the firing of it, which I would just reiterate, he already has served his sentence in that case, and that case is closed. He has no other cases pending before the court. We would ask for the court to allow a signature bond with his parent, his mother.
What states say?
So the facts and circumstances of the case, Judge, are like my colleague stated. However, we will see that it is circumstantial to say that he stole the firearm, but there's a presumption that if you're in possession of the firearm that's not yours, that you stole it. So how we get there is the owner of the firearm called the police, did a police report, and from that police report, that victim is saying the defendant knows where his firearms are. The defendant is also an acquaintance with the victim's juvenile. The victim's juvenile left the door unlocked. So it's what we're alleging is because the defendant had knowledge of where the firearms were and he was found in possession of that firearm and convicted of shooting that firearm, that he stole it. Furthermore, the defendant's prior criminal history. So the most recent case is 2023 CF 2515, where he was adjudicated guilty of possession of a weapon or ammo, and then also in the same case firing that weapon. In 23 CJ, I believe that was the same facts and circumstances of the previous case. However, in 22 CJ 448, he has burglary of unoccupied conveyance, larceny, petty theft. So we believe a cash or professional bond would be more appropriate given the past conduct of the defendant and his current conduct.
Is he a convicted felon?
Yes, Judge.
What's he charged with right now?
He's charged with burglary of a structure or conveyance and theft of 2 firearms.
2 separate counts.
Yes, Judge.
Your Honor, I would just put before the court that I don't think he would be able to post any sort of cash or professional bond. He's 16 years old. I think in a situation where money is not available for those types of things.
And my response to that is that's just one factor that goes into this determination.
$10,000 cash professional per count. Thank you.
Judge?
Thank you, Judge.
Thank you, Judge.
Thank you. All right, this is Rufus D. Neely. Court appoints public defender if I haven't already, but I think I will. I do.
Thank you, Your Honor.
Okay.
Judge, the state's not seeking pretrial detention. We're going to ask for a reasonable bond to be set. Cash professional, facts and circumstances of this case. So the defendant charged with aggravated assault with a deadly weapon without the intent to kill. In short, there was seems to be a verbal dispute between the defendant and his significant other, which culminated in him pulling out an AR-15 and pointing it at the victim. Those are the circumstances. The victim felt like she was in fear for her life and immediately left with her children. The record of the defendant merely includes driving infractions, so he doesn't have a history of violence. We're going to ask for a cash professional bond, Judge, and leave the amount to your Honor's discretion.
Well, I had a risk assessment hearing with Mr. Neely this morning. He was very, very cooperative.
He is, Your Honor.
Fully complied with the sheriff's request.
Yes, Your Honor.
Consented to searching his house, his car, and told him where he could find the guns.
Yes, Your Honor.
Isn't he a veteran?
He
Yes,
is,
sir.
Your Honor. He worked, had worked with Judge Mason in Veterans Court. He worked for Career Source and for Walt Beach
Is the
Police
victim
Department.
here?
No, Judge.
Right now, Your Honor, I work,
Well, he's got ties to the community. He worked with the Veterans Court, you tell me?
With Judge Mason in Veterans Court, yes, sir.
Was he living at that house that this happened?
Yes, Your Honor, and they're in the process of getting a divorce. They were talking about divorce when all this occurred, but, I mean, he does maintain that he never did pull the gun on her, and that he had just bought the gun, and that he doesn't even have ammunition to fit the gun. But he has cooperated fully. When you talk to him, he's very calm.
How many counts have we got?
Just one.
One, Judge.
We would ask for a small bond, Your Honor. He's currently He even drove to the jail to turn himself in, and of course, they, impounded the truck. So, I mean, he's tried in every way to cooperate.
What I'm gonna do is $5,000 signature bond, so he can sign himself out.
I'll explain it to you.
You don't have to put up any money, just, if you don't show up for court, you'll pick up another felony and they'll come after you for the 5,000, but I'm making it a signature bond, so you don't have to put up any money.
I will be there every court date, Your Honor.
No contact with the victim. You may go with Okaloosa County Sheriff's Office deputy to retrieve your personal belongings. So that means you make an appointment with Sheriff's Office and get a deputy to go with you, go get your clothes and stuff, but you can't have contact with the victim until you get this case resolved, okay?
And if it's not already an order saying that he can't possess guns during the pendency of the case, I know that he's cooperated and given his guns up, but in case
All right.
he's found with.
In Your Honor, he has no problem with that. He did indicate that he does want to file the petition for dissolution of marriage, and he doesn't want to be accused of third-party contact, and I told him since it was a legal proceeding that he was trying to go for, that it would not be third-party contact.
Right.
Because he wants to go forward with that.
Through
He
a
just
lawyer.
wants the court's assurance
Yes,
that
sir.
that's okay.
I just wanted to hear it, I can have the court do it as soon as I leave here.
Well, you can have,
The sheriff's office.
Yes, sir.
The state wouldn't find that a violation of pretrial release if he serves papers on his.
yeah,
Right.
as long as you're in a court proceeding, serving her papers, get you a lawyer, and the lawyer can contact her lawyer or her or whatever, but no contact with victim, may go to Okaloosa County Sheriff's Department may go with Okaloosa County Sheriff's deputy to retrieve personal belongings, no possession of firearms or ammunition, 5,000 signature bond per count. So sign yourself out and show up for court, and this court date is when, Ms. Santa? September 26th, okay?
Okay, and so that's gonna be for the civil, okay? But make sure that this is gonna be your criminal court date, okay? And call our office if you got any questions, okay? Mm-hmm.
Thank you, sir.
Yeah, you can process you out at the jail. Your Honor, this is Alana Stewart.
Stewart, okay. All right, go ahead.
Judge, we are not seeking pretrial detention at this point in time. We're seeking a reasonable bond. So the defendant was out on trafficking charges, 23 CF 2430. She has since picked up new trafficking and fentanyl charges. The facts of that case. So on the listed date, Deputy Jennings was at an address for a citizen contact welfare check on a female on the bench, the defendant. Jennings located the defendant passed out in the sand, but was unable to wake her up. Defendant was asked for her ID, gave the deputy permission to receive it. Deputy asked for consent to search her bag, and that consensual search yielded approximately 8 grams of fentanyl, which is a trafficking weight. So we're going to ask for a cash professional bond of $50,000 on the new charge, but I believe her bond has been revoked on the 23 case.
Well, has the PD been appointed?
Yes, Your Honor.
All right, what do you say?
Your Honor, unless anything's changed since yesterday, she's not seeking to get out. She wants a speedy resolution to resolve both of her cases, and once the state attorney assigned to the case gets back, we will be discussing that with her. So she has no objection to the $50,000 bond.
All right, 50,000 cash or professional per count. So hopefully you can get it resolved, okay? And I don't know if you're guilty or not, because I haven't heard any evidence, but if you're messing with fentanyl, it's terrible stuff, and stay away from it, okay?
And I'll come see you next week.
Mr. Velasquez.
I tried to see Mr. Velasquez yesterday.
Yes, you're right.
Mr. Velasquez, did they tell you I tried to come see you yesterday?
No.
All right, this is 2024 CF 1843 State versus Brian Velasquez.
Yes, sir. Cody Sprouse on behalf of the state of Florida. We're not seeking pretrial detention in this case. We're seeking for a reasonable bond to be set. We're going to ask for a cash or professional bond. The reason being, we want the defendant to show up for the process and to ensure that the community is safe. So the defendant had a warrant for a violation of probation in 23 CF 910. Deputy Eddie Sterling was patrolling, saw the defendant, knew that he had a warrant for his arrest, and attempted to arrest the defendant. During that attempt to arrest, a struggle ensued. The defendant ultimately was tased and apprehended. So we do think there is an issue for the defendant trying to show up and take responsibility because he ran from the cops. If we were to let him out on a signature bond, I'm afraid that we would place our deputies and police officers in danger of the defendant. So if we can have a professional make sure he shows up and for the process and has collateral, so he has more consequences for his actions, I think that'd be the most prudent.
What kind of bond are y'all looking for, Miss Rivers?
What kind? He doesn't have any money, Your Honor.
What's he charged with?
He's charged with aggravated battery on law enforcement. As I spoke to the state earlier, I believe it would be just a battery on law enforcement as alleged. He has a VOP, the 23 cases of VOP, and he is without funds to post any cash bonds.
Well, there's no bond on a VOP, but so we want 5,000 cash professional.
Thank you, Your Honor.
Yes.
Thank you, Judge.
All right, well, I will try again to come see you.
So I'm going to sit what I'm doing. More days or something?
You're going to sit there for a while, yeah,
How long?
till we get them resolved.
That's the last one.
Uh-huh.
Yeah.
Gilbert. Yeah, they already did it.
You got arraignments, right?
Yes, sir.
You want to start those, or you want to wait 7 minutes?
Judge, I could get started. There were a couple of people that you wanted me to go over revised plea offers with.
Okay.
So I could also do those.
Ready on those?
Well, if they're here and we've got other arraignments, I can go talk with them real quick.
All right, let me just go ahead and talk to them, and let me,
All right, Judge.
are y'all in the audience here for arraignments? Okay, what's going to happen, I'm going to tell you what you're charged with. And each of you have a right to an attorney. I'll be happy to appoint an attorney to represent you if you can't afford an attorney. You have the right to remain silent. You have the right to know what, you have the right to, well, the state may present you with an offer. You can accept that offer if you want to, and your case will be resolved today, but you certainly don't have to, because you have a right to a jury trial, and you have a right to remain silent. And so when I call you up, you'll be told what you're charged with. You can point you, and I'll appoint a public defender to represent you if you request one, okay? What about Archie Atkins? Is he here?
He's an inmate, sir. I'm getting my.
All right. Let me just start. Y'all raise your hand who's here for arraignments. I'll start with the gentleman with the little child.
What's your name, sir?
What's your name?
Tavares Maxwell.
Maxwell?
Come on up here, Mr. Maxwell, to the podium. Everybody come up to the podium when I call your name, okay? Javaris, all right. Mr. Javaris Maxwell, this is 24 CF 1568, charged with aggravated battery on victim that's pregnant, or aggravated battery on a pregnant victim. Would you like to have me to appoint a public defender to represent you?
Yes, sir.
Okay. I'll appoint a public defender.
Your Honor, men are not guilty and request trial by jury.
All right. We'll set, Mr. Maxwell, we'll set your court date for August 26th. But before then, get with Ms. Rivers at the public defender's office and see about working on your case, okay? Thank you. Next person here for arraignment on that row or the very next row behind.
Lennon Harris. Harris? Yes, sir.
Okay.
Lennon Wayne Harris?
Yes, sir.
Okay. This is 24 CF 1516 State versus Lennon Wayne Harris. You're charged with possession of a weapon or ammo by a convicted felon.
We're going to enter a not guilty plea, Your Honor. Request trial by jury.
Okay. August 26th. So get with Mr. Williams, I guess. He's with the public defenders. And be back on court on August 26th, okay?
And Judge, you called Archie Atkins?
He's in custody.
Dismissed. The VOP was dismissed. And
Just
then
bring him
I
out
believe the
when
new law
You
is
just
to-
come back and call Mr. Williams.
Atkins.
There was no.
So Mr. Williams isn't here right now, he went outside. So that's your next
Right, this is 24 CF 1550 State versus Archie Horace Atkins. State has an announcement.
I believe. No, this is not it. No, Judge, this is a different case. My apologies. There's a different case that we handled this morning.
All right, you're charged with possession of a controlled substance without a prescription, possession of stolen property, and narcotics, possession of narcotics equipment. This is arraignment, so you have the right to an attorney. Would you like me to appoint an attorney to represent you? Yes. Okay. I'll appoint the public defender to represent you.
Your Honor, we're going to enter a not guilty plea.
The offer in this case is an adjudication of guilt, $615 court costs, credit for time served.
All right, if you want to plead guilty or no contest, what I'll do is adjudicate you guilty, sentence you to time served in the county jail, $615 court costs.
That's a
If,
great,
if you're not a felon, it would make you a felon.
I'm ready to go home now, so.
All right, Mr. You're Archie Horace Atkins, right?
Yes, sir.
24 CF 1550. Would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God.
Yes, sir.
You want to enter a no contest plea to possession of a controlled substance without a prescription, third-degree felony. Possession of stolen property, I think that's a third-degree felony too.
That's correct, Judge. It was a
And-
shopping cart.
And narcotics equipment possession of first-degree misdemeanor, so you can put your hand down. So you want to enter a no contest plea to those charges, correct?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Right to a jury trial, right to make the state prove its case beyond a reasonable doubt, right to remain silent, other
Yes, sir.
rights. You understand you'll be a convicted felon, though, if I accept this plea. You understand that?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty, sentence you to credit for time served concurrent on each count, and $615 court costs. Give you 180 days to pay it before it goes to judgment.
Yes, sir.
Can't be around firearms or bullets or weapons.
Yes, ma'am.
Yeah, don't be around weapons, guns, firearms, okay?
Yes, sir.
I guess you'll be released today unless you're being held on something else.
Am I good to go this way?
Mm-hmm.
Thank you for your help.
So now back to the people in the audience. Who's the next one? All right, I'll start with this lady right here. What's her name?
Cicely Austin.
Austin? Cicely Austin, okay, 24 CF 1543. You're charged with burglary of an unoccupied dwelling unarmed and battery, a first-degree misdemeanor. Is there some type of offer for?
We did just get an offer, if I may have just one moment, Judge.
All right.
We did just get a new offer, Judge. She is going to need some time. If we could just plead not guilty today and leave this set for pretrial.
All right, August 26th, thank you.
Just for the court and the defense's edification, and be likely dropping the felony, so it's probably gonna go down to misdemeanor. It's a probation on the misdemeanor. I'd be willing to do a year of probation with an automatic term once anger management's complete and court costs are paid. You can't and don't contact Ashley Scott.
Judge, she would be willing to accept that today for a plea to the misdemeanor battery for a year of probation with early termination and complete anger management.
All right, Miss Austin, would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God.
Yes, sir.
You want to enter a no contest plea to the charge of battery, a misdemeanor,
Yes, sir.
and the state's going to dismiss the felony.
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Right to a trial, right to make the state prove its case beyond a reasonable doubt?
No, you wouldn't be a convicted felon.
Yes, sir, I understand.
Yeah, you're not going to be convicted of a felony. Was it y'all looking for a withhold or a adjudication? Withhold?
I'd ask for a
Okay.
Yeah, it doesn't,
So-
It's not going to make a huge difference.
it's a battery, so I don't think the differentiate.
All right, talking about withhold, which means you won't even have a misdemeanor conviction on this, okay? You understand that?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Withholds adjudication, place you on 1-year term probation. Regular probation will be terminated as soon as you immediately upon completion of an anger management class. Is it program or class?
It's a class, Judge. It's like 12 weeks.
Class.
Oh, no, hold on.
Yeah. Oh, you can also do an anger management class with a counselor, if I'm not mistaken.
I gotta pay,
Probation, as
do
far
I
as
have to
anger
pay
management
for
is
it? Am I
concerned.
responsible for paying for it? I'm disabled.
Does she have to pay for it? I
Sorry,
imagine.
in like Bridgeway or something, I think.
Right. She can sign up with Bridgeway, they have an anger management class.
And they have a cost reduction program too.
Correct.
I do,
I
I'm
think there's
good.
even one online.
I think they do one online as well.
All right, you can
That's-
do
that's
it.
much
I
cheaper
guess
as
if
well.
they allow you to do it online, you can do it online.
I'm okay with it.
As soon as you finish, your probation's terminated.
Okay, I'm
What
good.
was it, 615 court costs?
It'd be, I think, 622 is the court costs for battery.
622. I'll give you 180 days to pay it, or it goes to judgment.
Okay.
So costs are not part of a probation sentence, Judge?
I'll waive those. She's disabled.
Very well, thank you, Your Honor.
And the supervision fees are waived, is that
Yeah.
what you said, Justin?
All right.
Can we use the word shall terminate
Yeah,
upon completion?
yeah.
Thank you, Judge.
So get it done, and then you'll be on probation. Okay? All right, thank you. The next row of people that are here for arraignment, y'all raise your hands.
Your Honor, I have Miss Deborah Corey.
I'm going to take someone off the back row of the next one, because they keep...
Your Honor, Ms. Corey is present and approaching. Judge, this is 24 CF 1491. Ms. Corey would like to enter a plea of not guilty, request 15 days for any pre-arraignment motions, demand trial by jury, and leave this set for pretrial.
And the offer in that case is an adjudication of guilt, 615 court costs, credit for time served.
We received that today, Judge. She would like to discuss the case a little bit more before
All right,
making that
Ms.
plea.
Corey, you're charged with possession of controlled substance without a prescription. Your attorney's pledged not guilty. This is 24 CF 1491. See you on August 26th, okay?
Yes, Your Honor.
All right, thank you.
Get an appointment. Do you need a card?
All right, on the back row with the white T-shirt, or white shirt. Jackson? Henry Jackson? You, Mr. Jackson, this is 24 CF 1520. You're charged with felony battery.
Your Honor, we're going to enter a not guilty plea, request trial by jury. We'd like to
August
eight-
26th. Get with your attorney and get this case resolved, okay?
Sure.
Gentleman with the black T-shirt in the back row. Are you, is it Maxwell?
I'm Morgan.
Morgan? Tantiano Morgan, is that right, sir?
Antonio.
This is 24 CF 1533. You're charged with possession of a synthetic drug or constructive possession of it, driving license suspended, first offense, and DUI. Okay, would you like an attorney to, or is there an offer?
There is an offer, Judge, and just to perfect the record, he's charged with having a THC cartridge, like the concentrated cartridge, not synthetic.
Oh, okay.
The offer is DUI first offender minimums, and that includes an adjudication of guilt, 1129 probation, 515 court cost, 50 hours of of community service work, $500 fine, 6 months of driver's license suspension, victim impact panel, DUI school, 10-day vehicle impound. That's for the DUI.
Let me appoint the public defender, and he can go over, he can make sure this is what he wants to do.
I dismiss the POCS.
Your Honor, we're going to enter a not guilty plea at this time, request trial by jury, give them opportunity to meet with Mr. Williams.
All right, August 26th.
Your Honor, I have another out of custody, Mr. Grantham.
Dylan Kyle Grantham.
Yes, Your Honor. This is 24 CF 1482, Tim Gibbs on his behalf, Judge. We did receive an offer from the state. I've conveyed that to him. He would like to plead not guilty today and discuss the case a little bit more in detail before making that deal.
August 26th. Thank you, sir.
Thank you, Judge.
Who else we got back? About the Adidas shirt. Come on up. What's your name?
Brooks.
Gregory Brooks.
Yes, sir.
24 CF 1538. You're charged with driving license suspended, habitual second offense. Is there an offer for him?
What's the name, Judge?
Gregory Brooks.
Greg Brooks. This is getting sent down to misdemeanor. I gotta file a direct issue, capious, no capious, so I'm not gonna get rearrested on the charge. This is just not a felony. It's a DWLSR for sure.
All right, so it's going to be transferred to misdemeanor court.
Okay.
You're in felony court right now, which is a lot worse than misdemeanor, okay? So they're transferring your case down to misdemeanor court.
Yes, sir.
Probably
Right now?
It'd be in front of Judge Ward. I think
If Your Honor would be willing to take a plea on a
can't.
DWLSR.
It's from, it's in front of Judge, should be in front of Judge Ward. He'll have to do it.
Okay, Judge.
So what would be his court date in front of? Yeah, set him on the next county arraignment.
Would that be the 26th? Oh,
August 20th at 9:30.
okay.
That'll be in front of Judge Ward. That's county court. This is circuit court. Judge Ward's a lot nicer judge than I am, so he's a better judge.
Okay, Your
You're in a
Honor.
misdemeanor instead of a felony, okay?
Yes, Your Honor.
You got a piece of paper for him, Miss Hannah? We're gonna give you a notice here when to be in. Yeah, you don't want to be in front of me.
You might want to sign up for e-notify as well. The clerk has an electronic notification system. Like text message. You can go to the clerk's office and they'll help you set it up.
She's printing one off, I think.
And she's going to write you a notice now.
All right, thank you.
Thank you, sir.
You can ask for a public defender when you go to that court date if you need one.
Yes, sir. Thank you.
Okay, thank you. Who else we got out there without an attorney? This gentleman with the black T-shirt and gold chain.
Jerry Kleckler with C.
Wayne Kleckler, Jr.
Is that John Joseph Kemp?
No. Jerry Kleckler, Jerry Wayne Kleckler, Jr. CLECKLER.
I don't have him on the docket.
I show that a no process filed on that July 30th.
I don't know, I got my paper. It
What's
says
he
being-
charged with?
It was drug, this was
Possession. Oh.
And there's an all process in there?
For an additional process filed on July.
Okay, apparently they dropped the charges against you.
Okay, that's good to know.
Okay? No objection to that?
No, sir.
All right, thank you.
Thank you.
We're going to hold Mr. Berry in contempt for, who else out there's got a arraignment? Come on up with the bait, well, I'll get you next, ma'am. All right, what's your name?
Gregory Siegel.
Gregory Siegel, 24 CF 1567, you're charged with possession of narcotics possession of narcotics equipment, a misdemeanor, and a felony possession of controlled substance without a prescription. Is there an offer for him?
It's going to be an adjudication of guilt, 615 court cost, credit for time served.
You want to take that? Time served, no probation, no more jail time. Would you raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
You are Gregory Lamar Siegel, correct?
Correct.
You want to enter a no contest plea to possession of a controlled substance without a prescription, a third-degree felony, and possession of narcotics equipment, a first-degree misdemeanor. Do you understand that? You want to enter a no contest plea to those charges? Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you to time served on both counts. Concurrent 615 court costs will give you 180 days to pay it, or it'll go to a judgment. And adjudicated guilty. And don't wear shorts to court next time, or you'll go to jail for contempt of court. Don't come to any judge's court in short pants, okay? All right, thank you.
May I approach, Judge?
Yeah. All right, the lady back in the very back with the jacket. Christina Blair Russell, is that right?
Yes, sir.
24 CF 1569. You're charged with burglary, unoccupied structure unarmed, and grand theft. Looks like 2 third-degree felonies, I believe.
Can I get a case number, Judge?
24 CF 1569.
Right now, we don't have an offer at the moment.
I'll appoint the public defender to represent you, and they're going to plead you not guilty, ask for a jury trial, 15 days to file any motions, and August 26th, okay? Get with them to see if you get it worked out, okay?
Thank you.
August 26th.
Appointments on Wednesdays.
Anyone else back there in the audience that has an arraignment case today?
Judge, I've got one that I'm writing up a plea offer on. It's Mr. Maxwell, Darius Maxwell.
Okay.
Your Honor, Mr. Moore is back. Brooks is back. We gave him the wrong
I got it.
paper. His got reduced to Mr. May.
Yeah, I got it.
Make sure in court on August 26th. 9 a.m. Okay.
Y'all, Mr. Brooks, y'all are filing a misdemeanor, right?
Yes, Judge.
Okay. I don't want him to get in trouble.
I just got the wrong person docket.
Oh, you got the wrong person's docket?
Yes, sir.
Okay.
Yeah, I gave him the wrong thing, Your Honor.
Yeah.
We can just go down the list. So it'll first be Ms. Alford.
Regina Alford.
Your Honor, Tim Gibbs on behalf of Regina Alford. Judge, this is 24 CF 1313. Judge will enter a plea of not guilty, request 15 days for pre-arraignment motions, and demand trial by jury. Leave this set for pretrial conference.
All right, Ms. Alford, you are charged in 24 CF 1313 with animal cruelty. It looks like
Judge, there's 4 counts of aggravated animal cruelty and then 7 counts of cruelty to animals.
okay. And your attorney, public defender's pledged you not guilty, and we'll see you at pretrial on August 26th.
And otherwise, for the record, we did file a motion to reduce her bond earlier this morning that we'll ask to set for the 29th.
Okay, thank you.
This is your copy. Thank you, Judge. I had another person on docket, Judge Angela Durham. We sent an order yesterday to the court to have her transported. She's not here today. I'll plead her not guilty for today's purposes, but otherwise, we're expecting that she'll be transported to a group home, and we'll resolve the case otherwise.
That's correct.
Who's this lady?
Oh, she's here. Okay, fantastic. Well, we can bring her out and let her know if the court would like to know, but otherwise, we're getting her transferred to a group home. This is Ms. Durham's family. Yes, ma'am.
Can I speak?
What did you have to add?
Well, I wanted to talk to you.
Okay.
I'm Angela's sister. My name is Lily McCullough. I drove here 6 hours from Alabama yesterday, and for her court date today.
Ma'am, come up here. I can't hear what you're saying. Come up here, okay? All right, now what is your name?
My name is Lily McCullough, Your Honor.
Okay.
I am Angela Durham's sister. Me and my 2 children, we drove 6 hours from Huntsville, Alabama yesterday to be the whole court date today at 1:30. When I got the news that my sister had been, incarcerated, that really concerned me because I know her situation. I know her, she's epileptic, and I know her, I'm very aware of her mental disorders. And I understand that there's no other family members that is reaching out right now on my sister's behalf. But, I reached out all the way from Alabama. I did phone calls and everything. I even drove up here. I got my kids out of school, just to be here. And they're missing their first day of school just to be here. I did contact Susan, that's in medical at the jail. I spoke to her. I also spoke to Kelly from pretrial services. I don't know if they've taken down my information or said anything to you about it, but I am willing to take care of my sister. I am willing to go, the whole mile to take care of her because I know her situation. I have also contacted some group homes in my area for her. She does have a caseworker in my area that I had got started for her. Her name is Emily James. And Emily just recently told me that we cannot finish the application, the intake process for my sister because she's residing here in the state of Florida right now. She said that in order to do the application intake, my sister would have to be in the state of Alabama to do that. So we put that off on hold. There's 2 group homes that I contacted in my area. And they said that they are willing to help her. Mr. Tim Gibbs here and his secretary, as well as Kelly from pretrial services, they gave me information over the phone when I was in Alabama before I got here of a group home, Green Shades Group Home in Quincy, Florida. I've done some research on that group home. Well, there's not really much research that you can do on that because when you put it in Google or the maps, it's not popping up. You cannot find it, and they don't have a phone number. So that's one thing that's concerning me is they don't have a phone number where family can contact. All the group homes that I know of that where the intellectual children, disabled children and adults go to, there are phone numbers. That right there stood out to me, and it made me very concerned and worried for my sister's sake. They should have a phone number. Why they don't have a phone number? Is it a good group home? You know, it's the family is here in Florida, and most of the family doesn't have transportation or good transportation, so we cannot get to her all the way in Quincy, Florida. I'm in Alabama, you know, and I have to travel back over the weekend, you know, because so my kids can go to school. And I was just told by Mr. Tim Gibbs that my sister's going to be transported over the weekend. I might not be here. You know, and that's a long drive from where I live all the way up here. I'm just concerned about my sister. I just want to help.
Okay. Well, this is arraignment, and what you have just told the court needs to go to her attorney so he can file the appropriate paperwork or motions to see about. But we can't resolve the case today, which I think you're really wanting.
For the court's
that I know of. Yes.
As well, Mr. Sprouse and I did meet with the Agency for Persons with Disabilities, I believe last Friday on a video call. Several members from their team were present during that meeting and discussed the group home situation for sending Ms. Durham to Green Shades because she is a Florida resident. She has an intellectual disability that I believe has been diagnosed. APD has taken over her care, has placed her under their custody, and has found this group home. I'm sure that her family could, of course, reach out to the agency to find alternative placement options, especially if it is out of state. That might be something that they have to transfer. But she should be able to get in contact with the agency, and we can try to get that, facilitate that.
Yeah, there's
right.
how are the family going to contact? There's no phone number.
We'll see if we can get in touch with APD, but otherwise.
I assume she's pleading not guilty, right?
Assume, yes.
Okay.
She's pled not guilty.
All right, we'll get, pardon.
And the state, once she's transported to Gadsden County, we're gonna dismiss the case, so she'll be free to roam about as she wishes.
It'll ultimately be up to the Agency for Persons with Disabilities where she goes. If she has family that's stable in Alabama, then I'm sure that
All right, well,
facilitating that.
help.
What I'm trying to see is like.
All right, thank you.
Is there any information that I can have you, sister, when
All right,
she's
thank
going
you,
to this
ma'am.
facility?
I'll get with you after we're done.
Okay, this is one you're telling me. Yeah, okay, so it's a plea for Mr. Ballard. Okay.
Your Honor, this is Mr. Justin Diaz on 24 CF 1499, Tim Gibbs, Public Defender's Office. Judge, he shows us having Ms. Farkas with our office, but this case, I believe, was transferred from the South End divisions. We'll plead him not guilty and request 15 days for any pre-arraignment motions, demand trial by jury, and leave this set for pretrial.
All right, Mr. Diaz, you're charged with trafficking in heroin, trafficking in fentanyl, possession of drugs with intent to sell or manufacture, possession of controlled substance without prescription, and fleeing and attempting to elude law enforcement. So your attorney's pledged you not guilty and requested jury trial, and we'll see you what day, August 26th?
I believe that's when it's set for pretrial, Judge.
All right, okay. Your attorney will be up to see you. Thank you.
Thank you, Judge.
All right, Jesse Lee Howell.
Yes, sir.
Mr. Williams, have you had a chance to talk to Mr. Jesse Lee Howell?
I sure have, Judge. Let me grab this file off my.
This is 24 CF 1537. You're charged with smuggling contraband and possession of narcotics equipment.
All right, so I've gone over, the court appointed me on the new law violation earlier today. I've gone over Mr. Howell's rights with him, and I've gone over what the offer calls for, which is 1-year community control, controlled substance evaluation and treatment, and it'd be running concurrent on everything, and then fines and costs. Is this what you want to do, sir?
Yes, sir.
Okay. Do you need to talk with me further or anything like that? I can get you brought in on another date if you need to talk with me further.
No, sir, this will be fine.
Okay. Let me get your signature right there then.
Mr. Howell?
Now, you're the fellow who's worried you're going to be homeless?
Yes, sir.
Okay. Judge, we may be calling him back up after he talks with probation, okay? Because it may be hard to do community control with him, but let's let probation talk to him.
No, I thought the state suggested maybe more probation instead of community control.
Judge, I don't think probation's gonna work. He was already on probation, and he picked up these new charges. So I think the next step is community control.
Well, let's see what
Well, I don't want
probation
to take
work
a
with on it.
plea. I don't want to take a plea, and probation's going to tell me, well, he has no residence, he can't do community control.
Your Honor, homelessness in and by itself is not a violation of community control. He just has to let us know where he's homeless at. He can be homeless anywhere in the state of Florida, but he can't be homeless, he can't go to Alabama.
I'll be homeless here in Crestview.
All right, would you raise your right hand, or do you swear the testimony you give for us court's true, so help you God?
Yes, sir.
Mind if I date this for you, sir?
Yes, sir. And will I find out when I'll have to do the Bridgeway classes? That way I can be there? Because, I mean, I don't know
Yeah,
how to...
probation will coordinate with you
Okay.
on that.
Yes, sir. And do I have to be back at court on the 26th and the 5th?
Not now, because he won't have anything else holding him, at least not with us, not unless you got another court someplace else.
Yes, sir.
Just since you're on house arrest, if you've got any questions about whether or not you're allowed to do something, ask these folks.
All I would like to know if I'm allowed to work and go to the store.
Oh, yeah, you'll be allowed to work and go to school. That's not a problem. We want you to get a better life.
Yes, sir.
Okay?
And one more question. Do I have to let anybody know when I'm going to work or going to the store?
You're gonna meet with community control once a week, and you're gonna go over all that, and what date, and what time, or what day of the week, what time you're gonna go.
Yes, sir.
And what time you have to be back. You're gonna have a schedule,
Yes, sir.
okay?
Yes, sir. That'll be fine.
I notice you're being more sensitive with the inmates. I'm glad to see that, Mr. Williams.
He's not interrupting me while I'm trying to conduct a hearing.
Usually you're not as sensitive, but you're doing a good job. I mean, well, the inmates are sensitive people, so you know.
Yes, sir.
All right. All right, so, Mr. Howe, you want to plead no contest to grand theft, third-degree felony in 23 CF 2183, and introduction of contraband, a third-degree felony in 24 CF 1537, and possession of paraphernalia, misdemeanor in that same case number, 24 CF 1537. So you want to enter a no contest plea to those charges, correct? Did you read and sign his plea and sentencing agreement form?
The form that the judge, I just got from you, that the judge is holding up, is that what you read and signed?
Yes, sir.
Okay.
You understand the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On the misdemeanor count, the court judges him guilty, judges you guilty, and sentences you to time served in the county jail. And the felonies, you're adjudicated guilty, you're sentenced to 1 year 1 year community control concurrent in 24 CF 1537 and 23 CF 2183. Both have the same terms and conditions, standard court costs, $100 cost of prosecution, $150 PD fee, all go to judgment. And so basically, you got 1 year community control concurrent on each one of these, and time served on the misdemeanor, okay?
Thank
So
you,
get with probation, and they'll tell you about all those little details to make sure you don't mess up, waive cost of supervision, and try to go to school and get a job so you're not homeless, okay? Okay. All right, good luck to you.
Yes, sir. Thank you.
No problem.
So you can go and talk with them, and then come back to me and get your fingerprints. And we should have John
Eichel.
Come on out, please, sir.
Hey, John, what's your copy?
John Joseph Keipel, 24 CF 1579. You're charged with aggravated assault with deadly weapon without intent to kill.
Judge, I think this is one of the ones that maybe has another case coming up. In any event, I'm going to enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions. Let me just look real quick.
I don't have any other cases for Mr. Keuchel. I do have an offer though.
All right, he's got an offer for you.
That's correct. I'm getting him confused with somebody else. He's got a...
Offer is adjudication of guilt, 20 months DOC, $967 court cost.
I want to look into the case further before I sign him up or talk to him about a DOC sentence.
All right, your public defender wants to work on your case, so we'll see you on August 26th, okay?
All right, sir, you can take that with you. That's your copy, okay?
All right, 24 CF 1490, State versus Charles Wesley Kemp.
Judge, I'm going to enter a plea of not guilty on Mr. Kemp's behalf, 15 days pre-arraignment motions and trial by jury.
All right, Mr. Kemp, you're charged with burglary of an unoccupied dwelling, unarmed, and no assault, criminal mischief over $200, under $1,000, and resisting an officer without violence. Your attorney's pledged you not guilty, and we'll see you August 26th, okay? Thank you.
All right, sir. All right, take that with you. That's your copy, okay?
All right, this is 24 CF 1549, State versus Danny Burt Mason.
Judge, we've not yet been appointed on this case.
Mr. Mason, you're charged with fleeing, attempting to elude, failure to obey a law enforcement officer, and driving license suspended or revoked. Is there an offer for him?
Not at this time, Judge. He has 2 other cases that our office has not received the file for.
I'll appoint the public defender to represent you.
Thank you, Judge. All right, Judge, I'll enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions. I believe those other cases are set for September 5th.
We'll set him for September 5th then.
Thank you, Judge. Yeah, I'll have to bring a motion for you. Okay?
Thank you, sir. Thank you.
Thank you, Your Honor. Thank you, Jay. He has another case that we haven't received yet, so I don't have an offer. But
oh, this gentleman's going to be the
All right, this is Martin McDonald, 24 CF 1584. You're charged with third petty theft, a third-degree felony.
Judge, Mr. McDonald's got a total of 2 cases. He's got another felony petty theft that's set on August 29th. Is that the one you don't have a file on?
Correct.
Okay, so no info's been filed on that as yet?
I might have the file, but I haven't filed.
Okay. I was just asking for purposes of arraignment. I'll go ahead and, I'm sorry, sir? Squash it? Judge, would you squash all of his cases?
Upon motion and hearing, and if I find the evidence in law requires that, then...
So that's not going to happen today? All right, and we don't, the concept you're talking about is really more of a civil concept, okay? What you're talking about is a motion to dismiss, but motions to dismiss in Florida require you to admit the underlying facts, and that's probably not going to be a good idea. So, I've been doing this 34 years, if you're good with me continuing to handle it?
He'll talk with you, but he'll explain all that. But right now, he's saying you're not guilty, okay?
Right.
On to the next court date.
Next court, Judge, are you going to set him on the 26th, or?
Yeah.
Okay.
Might be, it seemed like you might be able to get this worked out, so he'll explain it to you, okay?
Okay, thank you.
All right.
All right, this is your copy, okay? Maybe by then you'll have the other one. Okay.
Next case is State versus William James McMurray Jr., 24 CF 1489, charged with petty theft, second or more prior convictions, 2 more prior convictions.
Judge, I'm going to enter a plea of not guilty on his behalf. Usual 15 days pre-arraignment motions, trial by jury. He's got a number of other cases that are already set for the 26th. The state has made an offer to cover all of his cases, but it's a Department of Corrections officer. It's a state prison offer, so I need to spend more time with him. We're not going to be doing that today.
Y'all with the little baby, you're free, unless you have any more court date? More court? You do? Okay.
Judge, we have a plea,
I-
I believe, on that one.
All right, I just didn't want them to think they had to stick around if they.
I'll talk with you about that, but that's going to require a longer conversation because you're going to be risking all. You're going to be risking any kids you have, being a grand and have kids on their own, would be risk. Now, I don't think he'd do that to you, but that would be the risk. So I need to spend more time with you. I'll come out to the jail before the 26th and we'll go over all that, okay? Okay, this is yours, okay? So you hang on to that. Now, Judge.
Mr. Stewart.
Stewart's not going to be on. Did you want to call out? Well, we'll do it in the order you've got it.
Put her at the end of the list.
Who we got here? Mr. Stewart?
Parker Lee Stewart, sir.
Parker Lee Stewart, 24 CF 1583. Okay, you're charged with smuggling contraband.
Your Honor, we're going to enter a not guilty plea. I believe a motion has been filed to transfer this to a division down south.
That's correct. So we filed a motion. I'm not
You'll-
sure
you-
if the order's
huh?
been signed
Yeah,
yet.
you'll continue to
but
have the same
My
time.
assistant definitely sent it over.
Okay. All right, well, you're going to be in front of a judge
It's
in
gonna be over
Port
there.
Walton. All right, thank you.
Your Honor, I have one right here, Logan Kilbrew.
All right. Logan Troy.
Yes, sir.
Killebrew, okay, 24 CF 1565, charged with trafficking in meth. And he's got Mr. Williams, it says on my docket.
All right, Judge, I'm going to enter, the state has filed an information. I'm going to enter a plea of not guilty on his behalf, usual 15 days for pre-arraignment motions, and trial by jury.
Okay, August 26th, thank you. Get with your attorney so you get it worked out. Yes.
I got a quick question. So I'm in Volusia County. It's Central Florida. It's about an 8-hour drive from here. Is there any way we can set up like a Zoom court date or something like that? It's expensive, and I got to take off of work. And
I'd have to do it for everybody. It's impossible. You got to be here in person for this.
Judge, one thing I will suggest, it's a trafficking case, so I don't see it getting resolved between now and the 26th.
All right, well, let's give him a further out date. What we'll do is set him for pretrial on October 28th. So you don't have to come back to court until October 28th and get with your attorney or call him or have a Zoom with Mr.
We've already spoken.
And maybe you can get it worked out and it'll be resolved on October 28th. But you
Thank
got to
you,
come
Judge.
back on October 28th instead of next week, and it ain't gonna get worked out.
Your Honor.
Okay, so save you some trips. Next time you're in court, remind me if you don't get it resolved, and we'll see about helping you out if we can with your transportation time frame. Okay.
Your Honor.
Okay. Thank you.
Thank you.
Thank you, Judge. Yeah. Yeah, that's the charging.
Oh, okay.
There you go. And from now on, court's always going to be at 9 in the morning.
I've got Miss Lige right here. Lige.
have her on my docket that I can see.
She's from this morning.
Go over that one more time.
Okay.
All right, Judge, we've got a plea agreement.
All right.
Okay, I'm being asked to make an inquiry of the state judge, if you'll give me just a moment.
This is 22 CF 450 State versus Desiree Giselle Lage.
All right, so Judge, I think we've got an agreement here. It's for 24 months community control, no violent contact with the victim, parenting class, mental health eval, and any recommended treatment, comply with the DCF case plan, court cost, cost of prosecution, and public defender fees. Got a score sheet. This is a downward departure sentence, Judge, based on legitimate uncoerced plea bargain. Her guideline score would be 32.7, lowest permissible.
That is the state's position.
All right, if this is what you want to do, Desiree, I need to get your signature right there, okay? We'll get you out of jail today. You want me to date it for you?
Ms. Lodge, would you please raise your right hand to be sworn? Would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God. Okay.
Yeah.
State of Florida versus Desiree Lage, 22 CF 450. You want to enter a no contest plea to the charge of child abuse without great bodily harm, a third-degree felony, correct? You do?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes.
Has anyone forced you or threatened you to enter this plea? Has anyone forced you or threatened you to enter the plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Ms. Lige, you look like you're very upset. Are you sure you want to enter this plea?
Yes.
Why are you so upset?
Because I feel like I didn't have a leg to stand on and I want to go home today. I have other children.
All right, well, I'm going to give you community control.
Yes, sir.
Instead of, I think the lowest guideline was supposed to get prison. You're supposed to get prison. I'm giving you probation, basically. Okay?
Yes, sir.
Was that what you were afraid of, is you were going to prison or something?
No, sir. I was afraid of having this type of charge on my record.
Well, court finds the plea is freely and voluntarily entered. Court accepts it. Judge is guilty. 24 months community control, no violent contact with the victim. Take a parenting class, mental health evaluation, and complete any recommended treatment. Comply with Department of Children and Family Services case plan. Standard court costs, $100 cost of prosecution, $150 PD fee, which can go to a judgment. Adjudicated and waive cost of supervision.
He's sending, he can't waive them, but he's sending them to a judgment, okay? So it'll go to collections eventually, all right? It'll be just like any other debt that you owe. You won't go to jail for not paying it. all
Okay.
right? And they're waiving the cost of supervision.
All right, thank you. Good luck to you, and make
Yes,
sure
sir.
you obey that case plan so you can get through with that court, okay?
Yes, sir.
All right,
Thank
thank
you.
you.
Thank you, Judge.
Manifest the Wayne Tatum. He's approaching.
All right, this is Dwayne Tatum. Oh, Wayne Tatum? Okay. Let's see, Wayne Tatum. Wayne Alton Tatum, 24 CF 1553. Okay, Mr. Tatum, you're charged with possession of controlled substance without a prescription.
The offer is a withhold of adjudication, $615 court cost.
If you want to enter a plea, I'm going to withhold adjudication, which means you don't have a felony conviction. Fine you give you a $615 court cost, 180 days to pay it before it goes to collection. So that's it. No probation, no jail time.
I'm in agreement, thank you.
All right, Mr. Tatum, would you please raise your right hand to be sworn? You swear the testimony you give for us court's true, so help you God.
Yes, sir.
You want to enter a no contest plea to the charge of possession of a controlled substance without a prescription. Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, withholds adjudication, orders you to pay $615 court costs. I'll give you 180 days to pay it before it goes to collections. No jail time, no probation. Okay?
May I approach, Judge?
Yes. All right, just pay that $615 court costs, okay? Okay.
Good luck. And then the last one on the arraignment docket is Jason Walterman.
All right, Jason. Jason Walterman, 24 CF 1518. You're charged with possession of controlled substance without a prescription, driving a license suspended or revoked, and possession of narcotics equipment.
May I have a moment, Your Honor?
Okay.
It made it. Credit times are $515, $100, and $100. $50 application fees, so that's $760. Court files, Okay. Your Honor, we're going to enter a not guilty plea, request trial by jury, and the August 26th court date.
All right, August 26th. Thank you, sir. Get with your public defender, see if you can get the case worked out.
Need to set up an appointment.
Next one is Michael Paul Owen. Motion, this is a motion to correct sentence, I believe.
Yes, Your Honor, this motion was filed by PD2, seeking to correct the sentence based on statements said in court. In the motion, it cited court rules saying that I would have to set a notice of hearing for this, and I have. And I did
Okay.
the motion in order to
What was the
transport.
problem with the sentence, the error?
Your Honor, the only thing I was trying to bring to the court's attention is at the time that you sentenced me, the state had suggested that the 12-1 was a mandatory sentence. And I filed case law with that stating and showing and proving that it's not a mandatory sentence. And what you told me that day is you had not acknowledgement of it being or not being a mandatory sentence. So because the state told you it was, you were going to sentence me to that according to what the state said. So I filed an appeal under the grounds that it wasn't. So I basically, Your Honor, I'll be honest with you, I'm here today to see if I can get a lesser sentence. I mean, I've got 53 days left if I do the whole 12.
Well, if I recall your case, Mr. Owens, I think the state was wanting 29.1 months in prison. And I said, no, I got to go with 12.1. I want to give you a break, give you
Yes,
the
sir.
least possible sentence I could give.
Yes, sir.
And my understanding of the motion was that your attorneys or appellate attorneys, or y'all felt that I was mandated to give you 12.1. I was not, I was giving you what when I said I got to go with 12.1 meant, let me put it this way. I want to give him the least possible sentence I felt I could give him, 12.1. And they wanted you to get 29.1.
Correct. I understand.
12.1 is a lot less than 29.1. So
The only reason I'm asking for it to be reevaluated and resentenced, Your Honor, and I understand that you did me a favor. You've done me a lot of favors in this case, Your Honor, for me to be honest, and I'm very appreciative of that. My old lady has been sick this whole time that I've been fighting this case.
no, 12.1, that's what I got to give you. Let me say that again. 12.1 is what the court feels is just, and that's the minimum sentence that I'm going to give. I did not want to give you 29.1, and I'm not going to give you 29.1. I'm giving you 12.1 as I did. Okay?
Okay, that's fine,
You're going to
sir.
be out in whatever.
53 days, Your Honor.
53 days,
sir.
okay? And then I also order you not to break the law when you get out.
Your Honor, I don't plan on being in the state anymore, but
All right,
I
well.
appreciate it.
Okay.
All right. Thank
All
you
right,
for bringing
thank
me
you.
down. Let me talk to you, sir. I appreciate it.
Okay. Yeah, don't break the law in any other state. You may not have a nice, soft-hearted judge like I am. Okay, now what do we got?
Mr. Maxwell, I believe, right?
Mr. Maxwell? Where's Mr. Maxwell?
He's with Mr. Williams.
Oh, okay.
Got one more judge, it's gonna be a plea, Martin McDonald. Let me get up to the microphone. Mr. McDonald, come on.
It's Maxwell.
Oh, you're calling Maxwell, not McDonald.
This is DeVarius. This is DeVarius Maxwell?
That's
DeVarius?
correct,
DeVarius Maxwell?
Sorry, I grabbed Mr. McDonald's file, they were both M's.
Okay.
I'm old. All right, so at any rate, Judge, this is going to be a plea to a misdemeanor battery.
All right, Mr. Maxwell, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, Your Honor.
Okay. Is that your baby back there?
Yes, sir.
That's a nice, well-behaved, quiet baby. Don't get in trouble anymore, because you got that baby you gotta take care of, okay?
Yes, Your Honor.
There you go, Judge.
All right, you want to enter a plea to misdemeanor battery. Is that correct? Down from a second-degree felony down to a misdemeanor?
Yes, Your Honor.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea?
Yes, Your Honor.
Anyone force you or threaten you to enter this plea?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Are you happy with the work Mr. Williams did for you on your case?
Yes, Your Honor.
All right, court finds the plea is freely and voluntarily entered, court accepts it. Judge guilty, sentenced to 12 months probation, 962 court costs, 50 hours community service work, which I'll let you buy out.
Parenting plan, Judge? Sorry, my handwriting's horrible.
Parenting plan,
Yes, sir. And for the record,
$100 cost, $100 cost of prosecution, $150 PD fee. Parenting, oh, okay, parenting. And plan, I'll waive costs of supervision, and everything can go to 180 days to pay it before it goes to a judgment. So 12 months probation, and just get that done, and then you'll be finished, okay?
Yes, Your Honor.
Okay, good.
in the way that he structured that.
I'm sorry, I just wanted to
stick
clarify
around, I'll
something
tell
for
you
the
how
record.
to Get on a payment plan with the court.
Mr. Williams? I'm sorry, I just want to clarify for the record. I believe the court announced parenting plan. It's actually parenting class.
Oh, parenting class.
I don't want to be tied up in something that wasn't intended.
Okay, parenting
Yes,
class.
please.
Okay. I can't imagine why we get